So on.
Please, Your Lordship.
Yes. Yes. Ah. Yes, Mukadappa.
Not the common issues in both the cases, that there are two petitions. I'm sorry.
Make use of mic. Yes,
No, there are two petitions, my lord. The common issue in both the cases.
same.
Yes.
In.
Now here, my lord, that the petitioners, my lord, that initially appointed as, my lord, police constables.
Ah.
My lord, subsequently, my lord, they were promoted as head constables.
ನಿಮ್ಮ ಕೇಸು ವಾಯ್ಸು ಎರಡು ವೀಕ್ ಇರಂಗ್ ಕಾಣ್ತಾವ. ಎರಡು ಹಂಗೆ ಅನಿಸ್ತದೆ. ಓಕೆ.
Subsequently promoted as, my lord, that the head constable and again promoted, my lord, PSI. And my lord, that under rule 32, my lord, the promotion one given to the first the petitioner, my lord, in 2016.
ಮೈಕ್ ನಲ್ಲಿ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇರಬೇಕು. ಇಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ ಅದು, ಬಟ್ ಏನೋ ಸಮಸ್ಯೆ ಇದೆ ನೋಡ್ಕೊಳ್ಳಿ, ಕರೀರಿ. ಎರಡು ಸರಿ ಹಿಂಗಾಗ್ತಾ ಇದೆ. ಎಸ್.
Lordship, hearing.
ಕಾನ್ಸ್ಟೇಬಲ್, ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್, then ASI ಬಿಟ್ರಿ ನೀವು, ASI then PSI.
Again, PSI, my lord, what had happened was, this was, though the vacancies were given, available, my lord, they were promoted on rule 32. But the first petition, my lord, he was promoted in 2016, whereas the second petition, my lord, he was promoted in 2017. Then not only these two petitioners, others, they were also promoted under rule 32. My
Why
lord.
are you using the word promoted under rule 32? A lawyer is not supposed to say that. Rule 32 is not a promotion ಅನ್ಕೊಂಡು ಒಂದು 50 ವರ್ಷದ ಇತಿಹಾಸ ಇದೆ ಜಡ್ಜ್ಮೆಂಟಿಗೆ.
My lord,
Therefore, you can say independent charge or in charge, only two, nothing else.
But the
See that
word-
B.N. Dhotrad versus
the wording they have
Land Army
used,
Corporation.
wording what they have used, I have raised.
ಅವ್ರು ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಹಂಗೆ ಹೇಳಿದ್ರೆ ನಮಗೇನಾಗ್ತದೆ ಅಂದ್ರೆ, ಐಡಿಯಾ ಆಫ್ ಪ್ರಮೋಷನ್ ಈಸ್ ಡಿಫರೆಂಟ್. ಐಡಿಯಾ ಆಫ್ ಪ್ಲೇಸಿಂಗ್ an employee in independent charge or in charge under rule 32 is different. That's what B.N. Dhotrad versus managing director holds. That is a very old judgment, though it is reiterated 2004 or 5 ಇರಬೇಕು Justice Najir Sahib. But that's a very old question. Anyway, we have understood now. It's not a case of promotion. Structure it that way.
But they were continued, my lord, on rule 32. But, my lord, the first petition, the second, they were retired, my lord, the first petition, he was retired in 2019. In the second petition, he retired in somewhere in 2017. But what had happened was, my lord, in 20,
ಏನ್ ರಿಲೀಫ್ ಬೇಕು ನಿಮ್ಗೆ?
ಅದರಲ್ಲಿ 2020 ನೊಳಗಡೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ರೆಗ್ಯುಲರೈಸೇಷನ್ ವಾಸ್ ಡನ್.
In the
ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ, ಬೇರೆ ಎಲ್ಲರಿಗೂ ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ಗೆ
ಇವರಿಗೆ ಸಿನ್ಸ್ ವಿ ಹ್ಯಾವ್ ರಿಟೈರ್ಡ್ ಫ್ರಮ್ ಸರ್, ರಿಟೈರ್ಡ್ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರು ಹೇಳಿದೆ, ಸಿನ್ಸ್ ಯು ಆಲ್ರೆಡಿ ರಿಟೈರ್ಡ್, therefore my lord, you are not eligible to be, but it is the only grievance.
My lord, the contention
Have
of the
you
state
given-
before the tribunal,
have you given that position to rest of the people
no, my lord, they have retired before they could be promoted.
before they could be promoted?
Promoted.
For others, ಏನಾಗಿದೆ ರೀ ಮೈಕಿಗೆ? ಕರೀರಿ ಅವನ್ನ. ಅಲ್ಲೂ ಆಗ್ತಾ ಇದೆ, ಅಲ್ಲೂ ಆಗ್ತಾ ಇದೆ, ಎರಡು ಕಡೆ ಆಗ್ತಾ ಇದೆ.
It is neither their case that their juniors were given an eligibility date prior to their retirement.
ಅಂತ ತೋರಿಸಿ. You
None
said
of their
that your
juniors
juniors have been.
That is the finding of the
Oh.
tribunal, my lord.
My lord, you lost my kindly.
Kindly show that.
Annexure A4, my lord.
A4.
A4, page 65, relevant portion I will point out.
Head.
First value.
Page 73, my lord.
ರಾಘವೇಂದ್ರ first value ಕೊಡಿ.
Page 73, you lost good.
ಬೇರೆ ಇದೆ ನೋಡಿ. First value ಕೊಡಿ.
Serial number 270.
Serial number 270.
Page 73.
Correct. Page ಯಾವುದು? 64 ಹೇಳಿದ್ರೆ ತಾನೆ?
64, my lord, that the opening page, but the last I am referring to page 73.
73.
Serial number 3 on the
73.
M. Shekarappa.
ಶೇಖರಪ್ಪ.
Yes, my lord, that the remarks column, what they say, retired before the deemed date.
Retired before the deemed date.
Yes,
So question of promotion will not arise.
ಅವರು ಹೇಳು.
ಅವ್ರು ಬೇಸ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಕೇಳ್ತಾ ಇದೀರಿ. ಹಾಗಾಗಿ ನಿಮಗೂ ಬರಲ್ಲ.
ಇಲ್ಲ, ನನ್ನ ಪ್ರಶ್ನೆ ಹೀಗೆ. What had happened was, my lord, that under the rules, the retrospective promotion is also the permissible one. Now here a case, what had happened was, my lord, there was a delay in processing it. The process was started because the vacancy position also I have said so even in my repetition, saying that how many vacancies were as on the date. Now what had happened in
How
this
long you were in Rule 32 position?
Rule 32, my lord, the first petition, my lord, from 2016 to 19.
2016 to 19.
Yes.
2016 to 19. ಆ ರೂಲ್ PPP ರೂಲ್ಸ್ ಕೆಳಗಡೆ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನಿದೆ? ಎಷ್ಟು ವರ್ಷ ಇರಬೇಕು ವಿತ್ ರೆಟ್ರೋಸ್ಪೆಕ್ಟಿವ್ ಪ್ರಮೋಷನ್ ಕ್ಲೇಮ್ ಮಾಡ್ಲಿಕ್ಕೆ?
It can be given with retrospective effect, but the contention of the state is, firstly, they were not promoted against the promotion quota. Because the direct recruitment was not done, they were placed in charge basis against a vacancy meant for direct recruitees.
Okay.
And neither their seniors, now my lord, if they are given
ಅವ್ರದ್ದು quota ನೇ
promotion
ಅಲ್ಲ.
from the date they became, were placed in independent charge, they will become seniors to their own seniors. That cannot be done. And none of their juniors have been given eligibility date prior to their retirement. That is the finding of the tribunal.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಈಗ ನಿಮ್ಗೆ ಪ್ರಮೋಷನ್ ಕೊಟ್ರೆ ಯು ವಿಲ್ ಅಕ್ಯುಪೈ ದಿ ಕೋಟಾ ಆಫ್ ಅದರ್ಸ್. ನಂಬರ್ 1. ನಂಬರ್ 2, ಯು ಬಿಕಮ್ ಸೀನಿಯರ್ಸ್ ಟು ಯುವರ್ ಜೂನಿಯರ್ಸ್.
My lord, since it is a promotional post, my lord, I have given the, my lord, the vacancy position. If they have given, you have taken a decision at the earlier stage itself, my lord, we got the regular promotion. That has not been done. There is no overlapping or otherwise, my lord. I am not claiming any promotion as against the direct recruitment quota. No.
ಅವರೇನು ಡೈರೆಕ್ಟ್ DR ಕೋಟಾದಲ್ಲಿ ಕೇಳ್ತಾ ಇದಾರ?
DR quota.
ನೀವು ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಇಟ್ಟಾಗ ಯಾವ ಪೊಸಿಷನ್ ಆ ಪೋಸ್ಟ್ಗಳು ಟು ವಿಚ್ ಕೋಟಾ ದೇ ಬಿಲಾಂಗ್?
Malad, independent charge ಅಲ್ಲಿ ಇಟ್ಟಾಗ ಅವರು DR quota against independent charge ಅಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು state contention.
ಎಲ್ಲಿದೆ ಅದು?
But finding is at page 130, Malad.
130.
Please. Paragraph 7 of the impugned order of the tribunal, which starts at page 129.
Second page 29.
Malad, there may be some mismatch. My page numbers are matching, not matching with
ಇಲ್ಲಿ
the
ನಮ್ದು
date
ಮ್ಯಾಚ್
of the-
ಆಗ್ತಾ ಇಲ್ಲ. ಹಂಗ ಏನೋ ಒಂದು
Para 7 of the impugned order, Malad.
Para 7 of impugned order ಯಾವ ಪೇಜ್ ನಿಂದ?
Impugned order is annexure C, Malad.
Kindly come to page 115.
1-1.
Para 7 ಓದಿ.
Para 7, yes.
ಓದಿ.
It is settled law that the applicants are not entitled to be considered for promotion.
Para 7.
Para 7.
It is not in dispute. ಯಾವ ಕೇಸ್ ಓದ್ತಾ ಇದ್ದೀರಿ? 17667 ತೊಳಿ. ನೀವು ನೋಡ್ತಾ ಇರೋದು ಅದು?
I'm sorry, my lord.
ಬೇರೆ ಯಾವ ಕೇಸ್?
File is not, the first,
File is
both
not-
are connected matters, my lord. The first file is not given to me. I have the
File is
second
not
file.
given to you. ಅದು ಇದೆಯಾ ನಿಮ್ಗೆ? 17667 ಇದೆಯಾ?
That file is not
Not there.
there.
ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿ ನೋಡ್ಕೊಂಬನ್ನಿ. ಅಲ್ಲಿ ಒಂದು ಫೈಂಡಿಂಗ್ ಇದೆ, ನಿಮ್ಗೆ ಅಗೇನೆಸ್ಟ್ ಆಗತ್ತದು. ಪ್ಯಾರಾ 7 ದಲ್ಲಿ
Please.
2014 ನಲ್ಲಿ ರೆಕಮೆಂಡ್ ಆಗಿದೆ ಅವ್ರ ಪ್ರಮೋಷನ್ಗೆ. BPC ಸ್ಟಾರ್ಟೆಡ್.
Please, no.
ಹಂಗಾಗಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Please.
Call immediately after occasion. I don't make it. Yes, sorry. Yes, sir. ಏನಿದು ಬಿಟ್ರೆ?
Lord, ಇದು promotions, Swami, from level 12 to 13A. UGC guidelines.
ಟೀಚರ್ಸ್ ಅನು
Oh,
ಲೆಕ್ಚರರ್ಸ್.
lecturers. Swami,
ಅದು ವೇಕೆನ್ಸಿ ಬೇಸ್ಡ್
non-vacancy based,
ನಾನ್ ವೇಕೆನ್ಸಿ ಬೇಸ್ಡ್.
non-vacancy based. ಇದಕ್ಕೆ interview ಇಲ್ಲ under the UGC regulations.
ಇವ್ರು ಇಂಟರ್ವ್ಯೂ ಫಿಕ್ಸ್ ಮಾಡ್ಯಾರ?
ಇವರು interview fix ಮಾಡಿ, my lord, I challenge the endorsement. In the endorsement, they do not say anything about the interview. My lord, in the reply statement filed before the KAT, my lord, they say that in the interview, my performance is low.
ಅದು ಅವೆಲ್ಲ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ.
ಹೌದು, ಅದಕ್ಕೆ
ಕಂಡೀಷನ್ ಏನಿದೆ ಅದಕ್ಕೆ?
ಸ್ವಾಮಿ annexure
ನಿಮ್ಮ ರೂಲ್ಸ್ ನಲ್ಲಿ, UGC ರೂಲ್ಸ್ ಅಲ್ಲಿ
UGC regulations, ಸ್ವಾಮಿ, page 75 ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ.
75. ಹಾ. ಇದು CAS ಪ್ರಮೋಷನ್ ಅನ್ನು
CAS promotion, my lord, my lord,
Page?
73, Roman 3.
73, Roman 3.
Assistant professor, selection grade, academic level to associate professor, academic level 13A.
Assistant professor is lecturer.
Lecturer,
Associate professor is reader.
reader ಅಂದ್ರೆ ಇದು ವೇಕೆನ್ಸಿ ಬೇಸ್ಡ್ ಅಲ್ಲ, ಇದು CAS, ಕ್ಯಾರಿಯರ್ ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್.
ಅದೇ ಗೊತ್ತಾಯ್ತು. ಹಾ. ಏನೇನ್ ಎಲಿಜಿಬಿಲಿಟಿ ಏನೇನಿದೆ?
ಎಲಿಜಿಬಿಲಿಟಿ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಹೂ ಹ್ಯಾಸ್ ಕಂಪ್ಲೀಟೆಡ್ 3 years of service in academic level 12, ಅದು ನನಗಿದೆ. A PhD degree in the subject relevant so and so, ಅದು ಇದೆ. Any of the following during the last 3 years completed one course so and so so and so, ಇದೆಲ್ಲ ಇದೆ ಅಂತ ನಮ್ಮ ಪ್ರಿನ್ಸಿಪಾಲ್ ಫಾರ್ವರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ನನ್ನ ಬಯೋಡಾಟಾವನ್ನು.
Now they say that is the Roman 3 you are reading.
ಹೌದು ಸ್ವಾಮಿ. Any one of the following during,
ಅಲ್ಲ, ನಮ್ಮ ಪ್ರಶ್ನೆ, are you reading Roman 3?
Roman 3 ಸ್ವಾಮಿ, page 73.
ಅವ್ರು ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಡಿನೈ ಮಾಡ್ಯಾರ ಈಗ?
ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಪೇಜ್ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಆಯ್ತು.
ಪೇಜ್ 77, Roman 4, ಅದರಲ್ಲಿ CAS ಪ್ರಮೋಷನ್ ಕ್ರೈಟೀರಿಯಾ, ಇದು CAS ಫಾರ್ ಲೈಬ್ರೇರಿಯನ್ಸ್. ಇದರಲ್ಲಿ ಆದ್ರೆ ಇಂಟರ್ವ್ಯೂ ಇದೆ,
ಅದರಲ್ಲಿ ಇಲ್ಲ. ಫಿಸಿಕಲ್
ಎಜುಕೇಶನ್ಗೂ ಇಂಟರ್ವ್ಯೂ ಇದೆ.
ಇಂಟರ್ವ್ಯೂ ತೋರಿಸಿ, ಎಲ್ಲಿದೆ ಇದು?
ಅದರಲ್ಲಿ CAS ಪ್ರಮೋಷನ್
ಇಂಟರ್ವ್ಯೂ
ಪರ್ಫಾರ್ಮೆನ್ಸ್.
This is absent there.
This is absent in level 12.
Cannot be made applicable to you.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
What is it?
ಇದೀಗ
How you can hold interview?
My lord, he is,
ಬೇರೆ ಏನ್ರಿ ಇದೆ?
my learned friend is appearing for the UGC, my lord.
State has to answer.
State has to.
What do you say? That exclusio ulterius principle apply ಆಗುತ್ತೆ. Where law prescribes two different procedures. The object is, to one it is applicable, to another it is not applicable. How can you hold interview? ಮತ್ತೆ ಅಲ್ಲಿ ಒಂದು ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಏನು? Why are you holding interview? Where is the requirement?
They have to submit the performance self-assessment.
Where is that? So that principal has said he has sent everything to you. How can you hold interview? It is only to control them. To mafia-like thing. Where UGC prescribes interview, you are entitled to hold. Where UGC conspicuously does not prescribe, you cannot hold. That's the law. Expressio unius, exclusio ulterius. That is the principle. What is your position?
Yes.
That's the correct position. Otherwise, they would not have done that rules at all. We have to allow that. No, nothing like that. ಎಷ್ಟು ಟೈಮ್ ತಗೊಂಡು ಹೋಗುತ್ತೋ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಇವಾಗ ನಾವು. ಇವೆಲ್ಲ 1 minute ಕೇಸ್, 1 minute ಕಾರ್ ಕೇಸ್ ಇದೆಯಲ್ಲ, 1 minute ಕಾರ್ ವಾಶ್ ಕಂಪನಿ ವರ್ಸಸ್ ಸೋ ಅಂಡ್ ಸೋ, ಹಂಗ 1 minute ಕೇಸ್ಗಳಿವೆ. Why are you insisting upon interview when the law does not prescribe at all? ಅಂದ್ರೆ ಅವ್ರ ಜೊತೆ ವ್ಯವಹಾರ ನಡೀಬೇಕು ಅಂತಾನೆ ಏನು? Why are you holding in interview? Interview ಬೇರೆ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡ್ಯಾರ, ಅವ್ರಿಗೆ ಹೋಗ್ಲಿ. Why for these people? Where is the stand you have taken in that before the KAT?
In the impugned order.
Impugned order, ನಿಮ್ಮ reply ತೋರಿಸಿ.
Reply, my lord, your lordship gets it at page 348.
348.
Oh. Interview ಇದು 352.
It is not based on a vacancy based, CAS. Any number of judgments is apex code. CAS is not dependent upon availability of the vacancies. How can you hold? On that ground, they have denied now. Where is that endorsement?
My lord, endorsement is at page 345, my lord, annexure A11.
345.
ಅದರಲ್ಲಿ ಇಲ್ಲ, ಇದರ ಬಗ್ಗೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದೀವಿ.
ಅದನ್ನ ಇಂಟರ್ವ್ಯೂ ಬೇಸ್ ಮಾಡಿ ಡಿನೈ ಮಾಡ್ಯಾರ ಅಂತ ಹೇಳಿದೆ.
ಅದು ಪೇಜ್ 352 ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್, ಮೈ ಲಾರ್ಡ್.
352.
ಹೌದು ಸ್ವಾಮಿ. para 9. It is submitted that the selection committee assessed the performance of the applicant by interviewing him and awarded the below cited marks for interview performance and assessment.
Further, we have to allow this.
My lord, kindly have a look at the finding of the tribunal, para 10, on this very point.
Once, very well, come to para. For a moment,
Please.
kindly see 352 of your own version before the
I-
tribunal.
Yes, notice.
Have you seen that table now?
Yes.
Yes. You have held interview
Interview
and you have assessed their performance, correct?
My lord, based on there are, my lord, subject to completing the minimum qualifying years of service, there are other conditions which have to be satisfied.
Which are there?
My lord, which relates to their performance during.
Where is that?
My lord, that is as per the guidelines, my lord.
Oh, show that.
And they have to submit,
Show me where are the guidelines prescribe interview for other set of people, not for these people at all.
no, not the interview, my lord. They have to submit a self-assessment.
You have done it on interview. That is your pleading.
My lord,
Otherwise, we would
the
not
word
perhaps.
may have been wrongly used there.
No, no.
My lord,
It
kindly.
is not paragraph. Kindly come to para 9.
No, I'm saying that the interview word may have been wrongly used there.
No, but you have held the interview. Leave that word English word, let it die. But come to your action. See the table. How could you do that? What is your authority?
But it is found that they did not satisfy the,
Oh, why should they should satisfy you?
uh,
Where is the requirement of satisfying you?
Rules do not. provide
Rules do
that.
not say, rules do not say that. In order to get this, you have to do that. That is not the position of law. What law does not provide for, you cannot do. Because you are an entity,
there are
legal
certain
entity.
performance parameters, my lord, that they have to
Where is that?
complete.
Where is
As per the regulations, my lord.
but allowed? In as much as the tribunal misdirected itself in law because it sanctified the interview procedure when the UGC, extant UGC guidelines do not provide for that. Wide page 73. First, this becomes apparent because interview procedure is prescribed for other category of employees. Wide page 77. First, next paragraph. In the reply statement filed by the state government before the tribunal, comma, at the paragraph 9, it is scripted as under. Para 9 ಇದೆಯಲ್ಲ ಇದು ಬರೆದು ಹಾಕಬೇಕು. That obviously shows that the performance of the petitioners was assessed by holding interview which the rules did not provide for, and that the performance appraisal in the interview is irrelevant for granting of CIS to the teachers going by the UGC, extant UGC regulations. First, next paragraph. The Calcutta High Court in so and so has held that all that is not prohibited is permissible to the natural persons, and all that is not provided for is impermissible for the legal persons. First, the entities functioning under the statutory rules, namely the UGC regulations promulgated under the UGC Act 1956, function as legal entities and not as natural persons. First, next paragraph. There is also force in the submission of Mr. Butt appearing for the petitioners in invoking expressio unius, exclusio ulterius, the principle which Broom's legal maxim at page number so and so, has said as under. First, our apex court in the decision of so and so has affirmed it as a rule of administration. First, no circumstances are pointed out to make the maxim inapplicable. First, in the above circumstances, petition is allowed, impugned order is quashed, writ of mandamus issues. ಏನ್ ಮಾಡ್ಬೇಕು? writ of mandamus ನಲ್ಲಿ ಏನಿದೆ ಆ ಪ್ರಕಾರ ಮಾಡ್ಕೋಬೇಕು.
ರೂಲ್ ಪ್ರಕಾರ ಮಾಡಿದ್ರು.
To consider candidature of the petitioners for the grant of CA status.
Level 12 to 13A.
The CA status is not dependent upon availability of vacancies. ಯಾವ judgment?
My lord,
Is that judgment?
my lord, ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಇದ್ದಿದೆ ನಾನು.
ಅದು ಇದ್ದದಕ್ಕೆ ಕೇಳಿದ್ದು, ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಅಲ್ಲ.
ಆಮೇಲೆ I will provide it to.
ನೋಡಿ, ಅವರು ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ಮೇಲೆ ಅದನ್ನ ಟೈಪಿಂಗ್ ಮಾಡ್ಬೇಕು, ಅಲ್ಲಿ ತನಕ ಮಾಡ್ಬಾರ್ದು. The apex court said as under.
Much of it.
Time for compliance. Yeah, this board.
Same issue, my lord, in the other two.
The subject matter of all the three petitions, common order.
Please.
Common matter, separate madam. Government. The subject matter of this petition is substantially similar to the one in serial number 2, wherein relief has been accorded to the petitioners therein, and therefore on the principle of parity, similar relief cannot be denied to similarly circumstanced persons. Vide 1975, 76 ಅದು ಅದೇ ಅದಲ್ಲ, ಅದನ್ನ ಹಾಕೋ DB judgment ಗೋವಿಂದ್ ಭಟ್ರದ್ದು ಅದನ್ನ ಹಾಕೊಂಡು ಮಾಡ್ಬೇಕು. Therefore, this petition is also allowed. ಎರಡಕ್ಕೂ ಈ ರೀತಿ ಮಾಡ್ಬೇಕು. Next, structure the judgment. Yes.
Serial number 3. Sub-registrar transfer through counseling.
Sub-registrar?
Transfer through counseling.
ಅದೇನು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ
ನಾವು ಲಾಗಿನ್ ಐಡಿ ಕೊಟ್ಟು ರೆಸ್ಟೋರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಿ, ಇನ್ನು ಮಾಡಿಲ್ಲ.
This matters, if my lords may recollect, on 10/12/2024.
Have you followed the order?
We have followed, my lords. We have filed compliance affidavits before this honorable
Filed.
court. And my lords, they had alleged that we are in contempt. This honorable court said file compliance affidavit. The concerned officers were before this court. After hearing the matter, and Advocate General also was there, I also appeared in the matter. This honorable court, prima facie, my lords, has closed the matters insofar as that allegation is concerned.
What was the, what
No,
is
my lords.
your grievance? Why
Yes,
they are
there was one
questioned?
more subsequent development. Because thereafter what happened, my lords, they had filed application, my lords, if, hello,
ಅಲ್ಲಿ ಏನೋ ಸಮಸ್ಯೆ ಇದೆ, ಅದು ಹೊಸ ಸಿಸ್ಟಮ್ಗೆ.
we console this also, please.
okay.
Lords, if my lords may recollect, on 16/12/2024, when these matters, my lords, were first listed before my lords passed an interim arrangement, my lords. Thereafter, my lords, we implemented that interim arrangement. During the course of winter vacation, my lords, matter was moved by them. And my lords, it was listed on 30th and it was listed on 31st. 31st, my lords have made an observation. Our undertaking was recorded that we are going to restore login credentials. Thereafter, master was listed on 1st of January, 7th of January, my lords, after the reopening. On that day, my lords, it was their case that we have not implemented the order dated 16/12 and my lords 31/12. My lords,
ಏನದು ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಏನು?
implement now ಮಾಡಿದೀವಿ. We have,
ಏನದು? What
my
is
lords,
that
implementation is, my lords, with regard to giving of course, my lords, on 16/12, what had happened, 10/12 was a transfer notification. Between 10/12 to 16/12, some officers, my lords, were relieved and they had taken charge.
Yes.
Some other officers, my lords, were in transit. Other officers were not relieved. My lords passed an order, my lords, of consisting of 3 paragraphs, operative portion, stating that those who are relieved and taken charge will not be given interim protection. That is, they cannot go back. Those who are in transit will be entitled to report to the same places. Other persons, my lords, who have not been relieved will be given interim protection. That is what it says. And my lords also said, my lords, that insofar as the petitioners, they are entitled to interim protection. My lords, thereafter, 3 days thereafter, my lords, I mentioned the matter before this honorable court that there was some overlap with regard to, my lords, categories, one paragraph covered by para 1 and 3. My lords had orally stated that you can take a decision because you are the employer in the matter. Thereafter, my lords, based on a legal opinion of the Advocate General's office, my lords, we have issued an official memorandum.
ಅದ್ಯಾವ ಕೇಸು? ಅದ್ರ 3 ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ಐ ರಿಮೆಂಬರ್.
ಇದೇ ಕೇಸಲ್ಲಿ
ಗೊತ್ತಾಯ್ತು. ಇದು ಇವ್ರ ಕೇಸ್ ಯಾವ್ದ್ರಲ್ಲಿ ಫಿಟ್ ಇನ್ ಆಗ್ತದೆ?
My lords, they fit in 3. But that is, they're entitled to interim protection. The petitioners, some of the petitioners, the persons, my lords, who are in 1 have already come and taken charge in terms of the post therein. So therefore, they were not supposed to be put back in terms of 1. So that was the overlapping case. Thereafter, my lords, we issued a detailed official memorandum of how to operationalize, my lords, with regard to the interim order, my lords, and that official memorandum was issued. And we issued movement orders. They filed applications seeking for stay of those movement orders during the course of winter vacation. Matter was listed, my lords, on thereafter no interim order was granted as against the movement order. On 31st, when my lord, it had come before my lords. 30th, it was listed before my lords, and it was listed before the vacation bench. Matter was adjourned to 7th. So on that day, my lords, no interim order was granted with regard to the movement order, my lords, that we had issued. Thereafter, my lords, 31st, they moved the matter, and my lord stated, restore the login credentials anta helidre. Adondu submission record madidre. 7th, my lords, it was their case that we had not complied with those orders, restoration of login credentials. Thereafter, login credentials were restored. We have filed two compliance affidavits, my lords, by the principal secretary as well as the IGR. Their case was that we are in contempt. Please don't hear the matter till we purge the contempt. Our case was we have fully complied and compliance affidavits were filed.
And court accepted it.
Court accepted it and said if they have any grievance, let them go and file independent proceedings. And matter was listed for final hearing. Thereafter, my lords, what happened was again matter was moved. Matter was listed, and that application that was filed during the winter vacation that was taken up. And my lords, the 10/12 transfer notification itself was stayed by this honorable court on the last date of hearing, challenging
normative process.
Normative process and that. Because what happened, my lords, I had already implemented the transfer order in terms of the orders passed by my lords. Then now the original order itself gets stayed by this honorable court. So therefore, my lords, we have approached the honorable Supreme Court. Matter is likely to get listed this week, my lords.
Ee week,
Ee week, my lords. Diary number is 15610 of 25. Challenging that order.
ಯಾವ ದಿವಸ ಇಟ್ಕೋಬೇಕು ಹಂಗಾರೆ ಹೇಳಿ.
My lords may take it any date after 21st, my lords.
ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಹಾಕುವ. 20.
Please.
ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ. Call this matter on 24 in as much as the state is before the apex court of the country grieving against order passed by this court. Interim order.
Please, my lords.
Grieving against the interim order passed by this court.
Dated 18/2/25.
Interim order will continue.
18
Today.
25.
25. First half. ಕೆಳಗಡೆ. Interim order as obtaining in these matters is continued.
Please. Grateful.
Next. 21st ಏನದೆಯಲ್ಲ?
24.
Okay.
Grateful.
Please, your lordship. Petitioners are surveyors who were appointed, my lord, under physically handicapped quota, have questioned the order.
Oldest matters ಯಾವ್ದು? Fresh matter. Notice ತೊಳಿ. Issue emergent notice. 707.
Please.
Learned DG is requested to accept notice for all the respondents who are officials. Okay.
Please.
Call along this matter. ಮೇಲ್ಗಡೆ heard learned senior advocate Mr. Shastri. Full stop. ಅದಾದ್ಮೇಲೆ issue emergent notice. Learned DG is requested to accept notice for the respondent. Yes.
If petitioners counsel, my lord.
Yes.
This matter was posted before your lordship during vacation bench, my lord. And at that time, your lordship said some inconvenience and it was actually.
Office objection ಏನಿದೆ ಕಾಮತ್?
Office objection, transcription ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ, translation.
C4 ಒಂದು ಹಾಕ್ಬೇಕಲ್ಲ ಮತ್ತೆ ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇರೋದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿ.
Maybe posted day after tomorrow.
Compliance within 1 week. Yes.
My lord, fee for the petitioner, my lord. Case of premature transfer. Last time, my lord, I've got only 1 year of service to attain superannuation.
Portions of the transfer order, my lord. The petition was not reported for duty, my lord. In this regard, my lord, the deputy superintendent, my lord, issued a showcase notice to the petitioner, my lord.
Well, last time it was learned government advocate was called upon to verify whether I can.
Last occasion, the counsel for the petitioner sought some time to, the suggestion made by the government that after the retirement of the respondent, my lord,
He will go.
he can be accommodated because her transfer is now sought to be set aside on the ground that she has been prematurely transferred. It is, my lord, after the amendment came into effect in March 2024, it became 2 years, minimum tenure became 2 years, my lord. She was transferred
Within that period.
Within that period. There was some confusion in what the officer has informed me is that there was some confusion as to whether the pre-amended rule has to apply or the amended rule has to
It
apply.
applies. It applies.
Indeed. Government has clarified that it is the amended rule, that is the 2 years tenure that is to be applied.
Then the matter has to be allowed now, unless you make some arrangement. The tribunal misinterpreted. Tribunal denied relief on what?
Yes, my lord, on the
One, my lord,
It allowed your
my
application.
lord, on the ground that she
Your
reported,
application.
she accepted the transfer.
How can that be?
Lords, my application is allowed, challenge to his subsequently, he was posted to Hassan rural. That is, that he challenged.
ಅಲ್ಲೇ ಅದೇ ಊರಲ್ಲೇ ಇರುತ್ತಾನೆ ಇದು ಎರಡು.
Traffic and crime.
crime.
3 places, my lord. Hassan traffic 1, Hassan traffic 2.
ಈಗ already you come to a consensus.
If they are agreeable, my lord, on the last occasion, counsel for the.
You
petitioner
said
to-
something, you said that.
I'm ready, my lord, to, if it, I am posted in traffic 1 or traffic 2, my lord, I'm ready to go.
ಏನ್ ಮಾಡಿ?
My lord, she is retiring in December 2025.
25. ಇದೇ ಡಿಸೆಂಬರ್ ನಲ್ಲಿ.
26, no?
25.
No, she is retiring.
26.
1 year, my lord, I've got 1 year of service.
Sarojabai,
Saroja Bai is retiring, the one who succeeded before the tribunal, my lord. She is retiring in December 2026, my lord.
26.
26.
ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ ನೀವು ಹೇಳಿ, ಒಂದು ಅರೇಂಜ್ಮೆಂಟ್ ಬನ್ನಿ ಕೂತ್ಕೊಂಡು,
I'm
ಅದೇನು
ready, my lord.
ಸ್ಟೇಟ್ ಗೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ನೀವು 3 ಜನ ಮಾಡ್ಕೊಂಡು
All
ಮುಗಿದು.
the places are only 3 kilometers away from each other. That is what I found out. It's not.
ಒಂದೇನ ಸಮ್ ಅರೇಂಜ್ಮೆಂಟ್.
I'm ready, my lord.
ಏನ್ ಮಾಡ್ಕೊತೀರಿ? ರೆಡಿ ಅಂದ್ರೆ ಎದಕ್ಕೆ ರೆಡಿ?
Traffic police station 1 or traffic police station 2, my lord.
ಹಾ.
if I may say one. Lords, initial arrangement where he was in rural, I was in traffic 2, she is in traffic 1 is made, my lords. That will be good for this reason. For me and her, both it is premature and without, for me initially without posting, subsequently. like this.
ಇಬ್ಬರಿಗೂ ಪ್ರಿಮ್ಯಾಚುರ್ ಆಯ್ತು.
Premature.
ಇವ್ರಿಗೂ premature ಆಗುತ್ತೆ.
I have-
ಇವರು ಕಂಪ್ಲೀಟ್
I have
ಮಾಡಿದ್ರು
completed
term.
my tenure in the earlier place.
ಆದ್ರೆ ನಿಮ್ಗೆ ಏನು ರೈಟ್ ಹುಟ್ಟಿದ್ದೇನು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ರೈಟ್ಸ್, ಹೌ ರೈಟ್ಸ್ ಹ್ಯಾವ್ ರೈಸ್ ಅಂದ್ರೆ ಹಾಫೆಲ್ಡ್ಸ್ ಟ್ರಾಪಿಜಿಯಂ ಅದನ್ನೆಲ್ಲ ಓದ್ಕೋಬೇಕು. ಅವಾಗ ಇಂಥವೆಲ್ಲ ತಪ್ಪು ವಾದ ಮಾಡಲ್ಲ. ರೈಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಕಾರಿಲೇಟಿವ್ ಡ್ಯೂಟಿ. ಅರ್ಥ ಪಾಯಿಂಟ್? ಪ್ರೊಫೆಸರ್ ಹಾಫೆಲ್ಡ್ಸ್, she has written it so beautifully. Samand also refers to that one. ನಿಮಗೆ ರೈಟ್ ಕೇಳೋದಿದ್ರೆ ಕಾರಿಲೇಟಿವ್ ಡ್ಯೂಟಿ ಇನ್ನೊಬ್ರಲ್ಲಿ ಇರ್ಬೇಕು. ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ರೈಟ್ ಇಲ್ಲ ನಿಮಗೆ. ರೈಟ್ ಯಾರಿಗಿದೆ? Those whose tenure is not yet over, ಅವರನ್ನು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. That is the object of rule, not something else. Those who have already completed, they have to go somewhere. That's the policy. ಈಗೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಆ ಪ್ರಕಾರ ನಾವು ಒಂದೇನೋ ಅರೇಂಜ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ನೀವು 3 ಜನ ಒಪ್ಪಿದ್ರೆ ಆ ಪ್ರಕಾರ ಮಾಡ್ತೇವೆ. ಇಲ್ಲ ಇನ್ನೊಂದು ಒಂದು ಹಿಯರ್ ಮಾಡಿ ಆ ಕಡೆಯಿಂದ ಈ ಕಡೆಯಿಂದ ಮಾಡಿ ಹಾಕ್ತೇವೆ.
Lord, if the status as it existed prior to all these transfers have to be restored, my lord.
ಅವಾಗ
The
ಸರಿ
order of the
10/8.
petitioner's transfer order has to be set aside as well as the transfer order of the.
person who has completed that tenure.
Yes.
Yes.
10/8/2024 order ಇಬ್ಬರನ್ನು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು. So,
Thereafter, he
both
can be
petitioner
considered for promotion.
Promotion consider.
Fresh promotion because he has completed his tenure. A direction may be given to
Fresh
consider in
promotion or
accordance with.
transfer?
I'm sorry, transfer, ma'am. To consider in accordance with law.
ಒಂದು ಚಿಕ್ಕದು ಅಂತ ಆದ್ರೆ ಒಂದು ಮೆಮೊ ಹಾಕಿ 3 ಜನ, so that it becomes easy. ನಿಮ್ಮಿಬ್ಬರಿಗೆ ಅವ್ರದ್ದೇನು ಪ್ರಶ್ನೆ ಇಲ್ಲ. He has to yield whatever you both will say. Government also agrees. ನಿಮ್ಗೆ ಅವ್ರು ಆಗೋದ್ರಿಂದ ನಿಮ್ ಭಾಳ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ. The petitioner, ನೀವ್ಯಾರು ರೆಸ್ಪಾಂಡ್, ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್?
Lords, respond number 4 in writ petition 340 of 20.
ಇದರಲ್ಲಿ 340 195 ಅಲ್ಲಿ ಯಾರು?
I am the fourth respondent.
ನಿಮ್ದಾಯ್ತು, ನಿಮ್ಗೆ ರೈಟ್ ಆಯ್ತು.
ಬೇರೆ
ಇವ್ರಿಗೆ
195.
195.
ಇವ್ರು ನೀವು ಯಾರು ಇದ್ರಲ್ಲಿ 195 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
ನಾವಿಲ್ಲ.
ನೀವು ಇಲ್ಲೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
Yes, I am the fourth respondent.
Subsequent order challenge.
ಬರ್ಕೊಳ್ಳಿ.
In 340.
ಹಿಂಗ್ ಬರೀ ಬಾ, ಸ್ಟ್ರೈಕ್ ಆಫ್ ದಟ್, ರಿಕಾಲ್ ದಟ್. A unanimous proposal is put forth by the petitioner in WP number 195/2025 and the respondent number
4 in 340 of
4 in companion WP number 340 of 2025 And the government has no much objection for restoring their position ante
As on 1/8/22.
qua transfer order dated 22/8/24,
10/8, my lord.
10/8/2024. ಅದ್ರಲ್ಲಿ ನೀವು ಕವರ್ ಆಗ್ತೀರಾ? You are also covered.
My tribunal has interfered, to his tribunal denied 24.
Okay, 2024. 24. First, learned counsel for the respondent
Number 4.
respondent number 4 in 195,
Yes,
WP 195, 2025 submits that some protection needs to be granted to his client also. First, we do not agree with this in as much as he has completed the prescribed tenure, and therefore such persons cannot have relief in the teeth of extant transfer guidelines dated
Police Act section 20.
Police Act 20.
Police Act.
They have a
Nodamma,
separate-
Police Act section 20,
F, sec 20F.
20F, 20FF, double F.
F, my lord.
Capital F.
Just one
F matra, 20F. First, ordered accordingly and writ petitions are disposed of. ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ತೀರಿ ಈ ಆರ್ಡರ್ನ? This arrangement shall be given effect to by the state and its officials
Within 2 weeks, my lord.
within 2 weeks. Within 2 weeks. ಮತ್ತೆ ಅವ್ರ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಎಲ್ಲ ಮಾಡೋದ್ ಬೇಡ. ಪಾಪ ಇಲ್ಲಿ ಸಕ್ಸೀಡ್ ಆಗಿ ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರೆ
That
First.
I've informed them, my lord. If
It
she
hardly-
succeeds, then we will not be able to hold it.
it hardly needs to be stated that the petitioner who is successful in getting relief at the hands of this court in a normative process cannot be subjected to any disciplinary inquiry for not joining the post to which he was transferred all these days. Yes. First, no cause.
Much.
But this word, common order. Yes, brother. Yes,
The
Mr.
office
Joseph.
objection pertains to non-translation, my lord.
Dispensed with.
My lord, I am aggrieved by the order passed by the Honorable State Appellate Tribunal, my lord, wherein the entrustment orders and the articles of charges were quashed. My lord, only on an erroneous ground stating that, my lord, this, the respondent number 3 here in, my lord, was a petitioner before the.
Issue emergent notice, interim order as prayed for.
So great.
Learned AG is requested to accept notice for
Respond number 1 and 2. my lord.
1 and 2. Emergent notice to
Respond number 3, my lord. Grateful.
yes. Satish.
I appear for the petitioner.
Ah,
Lord, matter pertaining to suspension. Lord, I'll give only 3 dates, my lord.
ah.
Petitioner was appointed as inspection officer on 29/5/2024 to submit an inspection report against the bank. Lord, 1 month time was granted.
Date, you know?
29/5/2024, appointment of the petitioner as inspection officer.
Ah.
30/5/2024, petitioner has issued notice to the bank.
Ah.
Lord, I am supposed to give, Lord, report within 1 month. I wrote a letter on 24/6/2024 that there are bulky records. I am not able to submit the report within 1 month. Please give me 3 months time. Lord, time was extended on 25/7/2024 by the registrar till, my lord, 29/8/2024.
Yes.
Lord, my appointment as inspection officer and, Lord, notice was issued, issued by me to the bank was challenged in writ petition 23075 of 2024.
ಅದೆಲ್ಲಿದೆ?
Lord, annexure A19 page 143,
ಏನಾಯ್ತು?
interim order of stay is granted.
ಪೆಂಡಿಂಗ್ ಇದೆ ಏನದು?
Interim, yes, my lord, I cannot submit the report. I am placed under suspension on the ground that, my lord, I have not submitted the report.
Things came to a head for him because he did not complete the inquiry.
No, how can he do?
The allegation is that because he did not complete the investigation on time. That is the reason,
No, extension is
This-
granted.
Extension is granted.
stake, extension was granted.
The
Lord.
officer has granted extension.
Extension was granted, but if he had completed
you-
the inquiry
have-
within the 1 month time prescribed. my
All
lord.
right, that question will not arise because extension is granted. Have you suspended who granted the extension? That official. What kind of orders are coming before the court? See, he said it is impossible to perform the duty. Give me one more. Your officer gave that.
Lord, after a preliminary inquiry, the joint registrar was of the opinion that he could have completed the inquiry within time.
But why did
That
he
is the-
grant the extension? No, no extension will be given. Then suspension could have been, easily you could have sustained. You have not done the job in time. Government is also wise. It knows what is the period to be given. How, why, tribunal, what tribunal say?
Tribunal says that, my lord, the interim order is granted. You could have sought for vacation of interim order before the
how?
High Court.
What
And,
kind of reasoning, brother? What kind of reasoning? What is his fault? ಸ್ವಲ್ಪ ಗೌರ್ಮೆಂಟಿಗೆ ಸ್ವಲ್ಪ ಹೇಳ್ಬೇಕು ನೀವು, ಅವ್ರಿಗೆಲ್ಲ ಬಿಗಿಯಾಗಿ ಹೇಳ್ಬೇಕು ನೀವು ಸೆಕ್ರೆಟರಿಗಳಿಗೆ. ಹಿಂದಿನ ಆರ್.ಎನ್. ಭೈರರೆಡ್ಡಿ ಅವರೆಲ್ಲ ಇದ್ದಾಗ ಗವರ್ಮೆಂಟ್ ಹೆಂಗ ಇಟ್ಟಿದ್ರು, ನರಸಿಂಹಮೂರ್ತಿ ಅವರು ಇದ್ದಾಗ, ಬಿ.ವಿ. ಆಚಾರ್ಯ ಇದ್ದಾಗ, ಉದಯವಾಳರು ಇದ್ದಾಗ ಬಹಳ ಬಿಗಿ ಇಟ್ಟಿದ್ರು, ಅಶೋಕನಹಳ್ಳಿ ಇದ್ದಾಗ. ಇಲ್ಲಪ್ಪ ಹಿಂಗೆ ಮಾಡ್ಕೊತ ಹೋಗ್ತಾರೆ. ಮಿಸ್ಟರ್ ಅಹಮದ್, ವಾಟ್ ಇಸ್ ದಿಸ್, ದಿಸ್ ಇಸ್ ಟು ಮಚ್. ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ನೀವು ಗೌರ್ಮೆಂಟಿಗೆ, ಈ ರೀತಿ ಮಾಡೋದಲ್ಲ. ಏನು, ವಾಟ್ ಈಸ್ ಹಿಸ್ ಫಾಲ್ಟ್? ನೀವು 2 ಸರಿ ಓದಿದ್ವಿ ನಾವು ನಿನ್ನೆ. ವಾಟ್ ಈಸ್ ಹಿಸ್ ಫಾಲ್ಟ್? Extension is granted. Still you want to put him under suspension. We don't understand. Issue emergent notice ಮಾಡಬೇಕಲ್ಲ? Issue emergent notice. Learned AG is requested to accept notice for the
both the
respondents. Interim order as prayed for. First, this interim protection we have given because the extension for accomplishing the task entrusted to the petitioner was accorded by the second respondent. Wide order dated
29, my lord, wide order dated 25/7/2024. 25/7/2024. Extension is till 29/8/2024.
And the extended period would expire, had expired on 29/8/2024. First, absolutely no culpa can be laid at the threshold of the petitioner. First up, we have also noted the pendency of WP number
23075 of 2024.
wherein,
Where interim order is granted on 27/8/2024, staying my inspection.
wherein interim order has been granted on 27/8/2024. Okay. Call this WP along with so and so. Monthly green state ಮಾಡಿ. This interim order should be implemented immediately. Otherwise, the defense of the respondent would be struck off.
I'm for petitioner in serial number 10. We are led by senior advocate Mr. Sajan Puvai in the matter.
Your senior is here. ಏನಿದೆ ಆದಿತ್ಯ? Puvaya is here.
He is honest, like he is there. Would your lordships kindly pass over, Manoj?
Pass over.
I'm sorry, Manoj.
Yes,
10 and 11 are both correct. 10 and 11 are together.
same. Okay. 10, 11, pass over.
I have filed this application, so writ petition, the challenge the portion of the order passed by the KAT, my lord. This is entitlement of is restricted from the
Urgency. Urgency ಅಂದ್ರೆ ಇದೇನು?
urgency, my lord, is they are all retired, my lord. They fixation has to be fixed in the grade, craft teacher grade 1, my lord, but they have fixed in the grade 2, my lord. This is a government.
Discrimination ಅಲ್ಲಿ certificate holder ಮತ್ತೆ diploma holder ಮೇಲೆ now we are also assailing that order. ಒಂದು 2 weeks time ಕೊಟ್ಟು we will.
ಅದು ನೀವು ಅಸೈಲ್ ಮಾಡ್ತೀರಾ?
ಮಾಡಿದ್ದೀವಿ. ಮಾಡಿದ್ದೀವಿ. Right.
Anyway, learned AG wants time.
And
Generally,
moreover,
not seek time.
12.
My original application.
Call after vacation. Yes, next.
Some of them have.
12 point.
At the request of learned AG.
Kindly fix the date.
For next bench, we cannot fix the date. Yes, next.
Disregard your lordship. Lokayukta, serial number 30.
Regarding amendment of 214.
214 2B2.
Lordship. Lokayukta has sent proposal to government to amend the 214.
That
Secretary
time.
present before the court, your lordship.
1914.
They want time, your lordship.
We want time.
There are.
It is under process.
ಏನೋ process ನಲ್ಲಿದೆ.
Amendment.
Immediate
Amendment to rule 214 2B, my lord. My lords have passed a detailed order last occasion, my lord.
Correct. But okay.
After vacation.
After vacation.
Much obliged.
ಆಗ್ಬೋದು.
All right. Next.
Much obliged.
Lord, I'm appealing for petitioner. My lord, I request some time in this matter, my lord.
You want time? ಒಂದು 2 ಸರಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನೋ ಮಾಡಿದ್ರಲ್ಲ ನೀವು?
ಹೌದು, ಬಂದಿತ್ತು ಮುಂಚೆ ಒಂದ್ಸಲ ಮಾಡಿ.
ಅದೇ after vacation at the request of
Interim order.
to continue.
Obliged.
Till next date of hearing. Yes.
Vijay Kumar. Petitioner while working as inspector, my lord, but a charge memo was issued without enclosing the statement of imputation based on which the charges were communicated. But he approached the tribunal granted an interim order. Now, my lord, by the impugned order, my lord, it has been dismissed on the ground that it is premature and therefore, my lord, the application is sought to be dismissed. Rule
Charge
62.
memo ಕೊಟ್ಟಿರಲಿಲ್ಲ.
Charge memo without enclosing the imputation of charges.
ಕೊಡಿ ಅಂತಂದ್ರೆ ಕೊಡ್ತಿದ್ರಲ್ಲ. ಅವ್ರಿಗೆ ಕೇಳಿದ್ರ ಹಿಂಗಾಗಿದೆ ಕೊಡಿ ಅಂತ?
Yes, my lord, but they have not furnished. They say.
ತೋರಿಸಿ.
In the reply statement, my lord, I have stated at page.
Stated ಅಲ್ಲ. Where is your letter asking them charge memo ಕೊಟ್ಟಿಲ್ಲ ಕೊಡಿ?
Lord, I had submitted my explanation to the charge memo. I was unable to explain properly, my lord. Therefore.
Where did you take up? ನೀವು ಇದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಹಾಗಾಗಿ I am unable to explain ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ? ತೋರಿಸಿ. ನಿಮ್ಮ
Page 71.
Page
71.
71.
Yes. He was absent to duty for the reason that he met with an accident and, my lord, he has fractured his leg. My lord, on the basis.
Where have you stated that ನಂಗೆ charge memo ಕೊಟ್ಟಿಲ್ಲ ಹಾಗಾಗಿ I am in a disadvantageous position?
That he has not stated in the reply, my lord.
Otherwise you would have said that. Now you have invented by your legal engineering.
My only submission is this, my lord. Rule 62 categorically says that.
Where have you asked for that? Where have you told them? Charge memo ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ ಹಾಗಾಗಿ I am unable to answer.
Well, it is the duty of the.
Where is that question arises only when it is not given to you? Where have you stated you are not given none?
Lord, it's a legal issue, my lord.
Dismissed. Next.
Similar matters are stayed by this honorable court.
They already stayed.
Yes, madam.
Note, issue emergent notice, interim order as prayed for. First up, Calgary. This interim protection has been granted acting on the assertion of learned AGA that in similar matters, this court has granted such protection, namely WP number so and so.
Posted
Call
along-
this matter along with.
Along with connected matters.
WP note ಕೊಂಡು ಹೇಳಿ ಅವರಿಗೆ. Yes, next.
At 17,
Yes.
this is the second round of litigation before your lordship.
Yes, you wanted to produce certain documents, na?
ಇದಲ್ಲ, ಇದು ಬೇರೆ ರೀತಿ NCLAT ಆರ್ಡರ್ ಮೇಲೆ. But the first respondent.
Yes.
But the first respondent who claims to be an operational creditor, he filed a petition under section 9 before the NCLT. But the petition was admitted by the NCLAT on 27, the dates may not be relevant, it was admitted by the NCLT.
Yes.
But against that, my lord, the appeal was prepared before the NCLAT. There was an interim order staying the operation of the admission because it results in moratorium and all that. Then the writ petition was filed, my lord, challenging the admission and all, my lord, ultimately because of the interim order, my lord, the writ petition was withdrawn.
Yes.
Now during the pendency.
Perhaps it went to Supreme Court also. Yes.
During the pendency of the appeal, my nominee director, the sole director, resigned. This was brought to the notice of the NCLAT. Now, in the meanwhile, I had, this date may be relevant, 12/8/2024, this date may be relevant. 12/8/2024. The sole director, nominee director of the petitioner before your lordship.
ಅಲ್ಲಿಗ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ ಈಗ. Dispute of or still pending?
It's NCLAT, my lord, again passes an order which is on the face of it arbitrary.
Why?
The reason is this, I'll give the date. My lord, in the, I am the Mr. Bhaskaran was the nominee director of the respondent before the NCLT, that is Tarun Realtors, who is the creditor, the operational debtor. He resigned on 12.
Which respondent here?
My lord, he is the petitioner in the connected matter, serial number 20. He is my director. He is my director. Tarun Realtors is the respondent before the NCLT. I own 49%, 49.9%. Bhaskaran was the sole suspended director nominated by me.
You take emergent notice, you'll call this on.
But on the face of it, I'll demonstrate how. Now the trial, your lordship directed the NCLAT to consider my application for restoration of the application because my application was not listed on that day. Now the NCLAT dismisses on the ground that you have invoked section 151, rule 11 is invoked, and the constitution bench judgment of this on the 5 judges bench of the National Commission says that the NCLAT has the inherent power to recall the judgment itself. And the Supreme Court also says under rule 11, they have the power to recall. The matter is not decided on merit. It is decided on the ground that the application and filed under section 151 is not maintainable. But I will only demonstrate this.
Where is that order?
Kindly similar. Page number 37.
37.
Completely pervert finding. Page 37. Your lordship directed the matter back to the NCLAT. 37, I'll only read one paragraph. The present recall application has been filed pursuant to your lordship's order. There are few facts which emerges for consideration by us that the power of recall is not the power which is specifically vested in the appellate tribunal, except for owing to exceptional circumstances as caught by the 5 judges bench of the principal. This supports my case, that is Union Bank case, wherein the power to recall has been confirmed to be applied, subject to certain embargoes as contained in that the judgment on recall does not have universal applicability, and more particularly when the recall in itself do not be significant. Since the same has been preferred under section 151, it is not 151, rule 11. Then kindly see next one. There is yet another reason.
All right, heard.
No, CRP proceedings.
You want to argue even after court?
No,
wants to give? We don't understand these things. Really, we don't understand these. Heard, learned senior advocate Mr. S. Basuraj appearing for the petitioner. He takes us through contents of impugned order and impugned order, telling that there is a misdirection of law attributable to the appellate tribunal, which gives more importance to the provisions of section 151 CPC, regardless of the law declared by the 5 judgment decision of the National Tribunal. First off, issue emergent notice, interim order as prayed for.
But there is
Till
one
next, no interim order, sir?
interim order ಕೊಟ್ಬಿಡಿ, ಆಮೇಲೆ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಕಾಗಿತ್ತು, ಅದರ್ ಸೈಡ್ ಬಂದ ಮೇಲೆ ಮಾಡ್ತೀನಿ. Some concern, my lord, I have to express. Your lordship, can I with the your lordship directed the NCLAT
to consider my application if I file an application for recall. Now, I am sorry to say, the honorable judges of the High Court, when they occupy the statutory position, they think that
Still they are High Court.
yeah, the Article 226 hangover continues. This particular judge appears, he found fault with your lordship's order. How can the High Court pass this order? Another judge said, I will report to the Supreme Court. Now, this kind of tendency has to be curtailed. They choose to be part of a statutory power. They accept the statutory position and they still think that they have the constitutional power. They left, right and center with impunity question the power of your lordship under Article 227. Now, Sampath Kumar is very clear that the basic structure of the constitution include the power of the High Court to supervise even the statutory
All
tribunal.
tribunals.
All
within
tribunals,
justice. Correct.
all tribunals, including the governor.
Correct.
I will say even though the executive head. Now this judge, and there are several other judges, and in one matter, His Lordship Justice Kumar initiated contempt of court proceedings. Therefore, when the High Court judges occupy this position,
DRT
yes,
matter.
let them realize that they are occupying a statutory position,
And they
this
are no longer
constitute-
the High Courts.
and this 226 hangover should, my lord, should recede. My lord, I will make this submission when the other side is there because
It was, I think, Khushwant Singh who said, to get rid of hangover, be drunk always. Anta.
For this
Hangover
is not-
comes a day, one day after the drinks are finished.
this
Such
is not-
hangovers are.
But they should not accept the statutory position if the thing
Not.
still they
ಅವ್ರು
continue to have that
ಅಪೋನೆಂಟ್
hangover.
ಬಂದಾಗ ಒಂದ್ಸರಿ ಹೇಳಿ, ಯಾಕಂದ್ರೆ ಯುನಿಲ್ಯಾಟ್ರಲಿ
Certainly, I shall-
ಅವಾಗ ಅವ್ರು ಇದ್ದಾಗ ಹೇಳಿದ್ರೆ
Certainly,
we can, if it is true,
certainly.
we can tell them, ನೋಡಪ್ಪ ನಾವು ಹಿಂಗ
That is why this is the submission I wanted to make. 20 also, my lord. 20.
Same.
Yes.
20 also, same order. ಅಲ್ಲಿ ಎರಡನ್ನು ಜೊತೆಗೆ ಕರೆದ್ಬಿಡಿ. ಜೊತೆಗೆ ಬಸವರಾಜ್, let them be called along with, call along with
He has filed the appeal.
all. Yes,
Maybe connected to 17 and 20.
yes, 17 and 20. Yes,
My petitioner is a chief engineer, my lord.
yes.
Against him, my lord, DA case was registered in 2024. Then, my
Good.
lord, that proceedings were questioned before this court. This court passed an interim order, my lord. Initially, they shall not file charge sheet without leave of the court, no coercive steps taken. On the same allegation, I am kept under suspension. I approached the tribunal, my lord. Tribunal, my lord, initially got an interim order in 15/10/24. Later, my lord, dismissed the application. My lord, I am before your lordship, my lord, questioning the order of the tribunal. Namely on two grounds, my lord. 10/10/24 is the suspension order, short of 2 days for 6 months. Lord, F5. And Lord, the
ಈಗ ಸಸ್ಪೆನ್ಷನ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರೆ ರಿವೋಕ್ ಆಗಿದ್ದ.
ಏನು ಮಾಡಿದ್ರು? ಸ್ಟೇ ಇತ್ತು ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ.
ಸರಿ, ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಾಡೋಣ.
Fresh
Fresh matter.
ನೋಟಿಸ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ.
My lord, may I kindly state why? Because, my lord, my lord, 6 months would expire.
Let's see,
My lord, 2 days.
let's see.
For a moment, may I appeal to your lordship, my lord?
Just next.
This is a matter where, my lord, the allegation is made against the petitioner. That is, it is unbecoming of a public servant for the reason that he has alleged to have been made certain conversation that your lordship.
ಅದು ತರಿಸಿದ್ರಾ?
ತರ್ಸಕ್ಕೆ ಹೇಳಿ.
ಪೆನ್ ಡ್ರೈವ್ ಬಂತ?
ಪೆನ್ ಡ್ರೈವ್ ಕಮ್ಮಲ್.
ಬಂದಿದ್ಯಾ?
ಪೆನ್ ಡ್ರೈವ್.
1:30 ಇಟ್ಕೊಂಬೋಣ ಚೇಂಬರ್ನ. ಬಂದ್ಬಿಡಿ 1:15 ಅಲ್ಲಿ. Let us see what he has said. If he has said, what according to he has said?
He has.
ಏನಂದ್ರು? What he said about the chief minister?
ಏನು ಹೇಳಿಲ್ಲ. ಏನ್ ಹೇಳಿದಾರೆ ಅಂದ್ರೆ 25,000 ರೂಪಾಯಿ ಯಾವ್ದೋ ಕೆಲಸಕ್ಕೆ ಅಷ್ಟು ಕೊಡದಿದ್ರೆ ಏನು ಕೆಲಸನೇ ಆಗಲ್ಲ. ನಾನು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಅನ್ನು ಬಿಟ್ಟಿಲ್ಲ, MLA ಗಳಿಗೂ ಬಿಟ್ಕೊಟ್ಟಿಲ್ಲ, ಇಷ್ಟೇ ಹೇಳಿ. ಮೇ ಐ ಪ್ಲೇ ಇಟ್, ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಇಸ್ ಇನ್ ದ ಐಪ್ಯಾಡ್.
ಕೊಡಿ ನೋಡ್.
ಬೇರೆ ಇದ್ರೆ ನೀವು ಹೇಳಿ.
ಆದ್ರೆ ಹಂಗ ಹೇಳೋದು ನಾನು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ಗೂ ಬಿಟ್ಟಿಲ್ಲ, ನಾನು ಮಹಾರಾಜ್ಗೂ ಬಿಟ್ಟಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ,
that itself is an arrogance which does not accord with rule of law. Chief minister is our minister, chief minister.
ಅಲ್ಲ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ
oh, he is not from Pakistan. He is our chief minister, elected leader.
ಅಲ್ಲ, ಅವ್ರು ಹೇಳಿದ್ದನ್ನೇ ನಾನು
ಬಿಟ್ಕೊಟ್ಟಿಲ್ಲ
ಅಂತ ಅಷ್ಟೇ ಇರುತ್ತೆ.
We'll see. ನಾಳೆ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ there should be the absence of audacity in the officials is the requirement of discipline.
According to me, my lord,
to anybody. ಅಡಾಸಿಟಿ ಇರಲೇಬಾರ್ದು.
ಅದಿಲ್ಲ ಅಂತ
ಮತ್ತೆ ನೋಡೋಣ, ವಿಲ್ ಸಿ ದಟ್. ಕೊಡಿ.
ವಾಲ್ಯೂಮ್.
ನನಗೆ ಅವೆಲ್ಲ ನಂಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಐ ಡೋಂಟ್ ಟಚ್ ಕಂಪ್ಯೂಟರ್ ಆರ್ ಲ್ಯಾಪ್ಟಾಪ್. ಐ ಆಮ್ ಅನ್ ಅನ್ಟಚೇಬಲ್.
ಅದಕ್ಕೆ ಆಯ್ತು. ನಾನ್ ತಿರ್ಗಾ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವೆಲ್ಲ ಅಂತ ಹೇಳಲು ಈಗ ಲೈಸೆನ್ಸ್ ಪ್ರತಿಯೊಬ್ಬರು ನೋಡಿದ್ರೆ ಖಚಿತವಾಗಿ 25,000 ರೂಪಾಯಿ ಇಸ್ಕೊಳ್ಳೋದಾಗುತ್ತೆ. ಆಯ್ತು, ಪರಿಚಯ ಇರೋದಾಗುತ್ತೆ. ನೀವು ಮುಖ ಬಂದ್ರೆ ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ಕೊಂಡಾಗ ಅದು ವಿಷಯ ಇನ್ನೊಬ್ಬರಿಗೆ ಗೊತ್ತಾಗಿದ್ದಂಗೆ ಸರಿ. ಇವ್ರು ಏನ್ ಬಂದ್ರು ಒಂಚೂರು ಇದೆಲ್ಲ ಮೂವ್ಮೆಂಟ್ ಮಾಡಿ ಇದನ್ನು ಕಂಡು ಇವ್ರು ಕೊನೆ ಪಕ್ಷ 10 ರೂಪಾಯಿ ಕೊಡೋದಕ್ಕೆ ಬಿಟ್ಬಿಟ್ಟು ಅಂದ್ರೆ ನಾಳೆ ಯಾಕೆ ತಿಳಿಸೋದೇನಿಲ್ಲ ಇಲ್ಲಿ. ಅದಕ್ಕೆ ಹೇಳಿದ್ರೆ ನೀವು ನೋಡೋಣ ಅವರಿಗೆ. ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಾನು ಹೇಳಿದೆ ಅವ್ರು ಫೀಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಬಿಡ್ಬೇಕಮ್ಮ. ಯಾವಾಗಲೂ ಏನಾದ್ರು ಆಗಿದೆ ಅಂತ ಹೇಳಿದೆ. ಅವ್ರು ಮತ್ತೆ ನನ್ನ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ಅಲ್ಲಿ ಸುಮ್ಮನೆ ಹೊಡೆದೇ ಬರೋದು ಸರಿ ಇರಲ್ಲ. ವಿಶ್ವಾಸದಲ್ಲಿ ನಾನು ಲೈಸೆನ್ಸ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ. ಮಿಕ್ಕಿದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಬಿಡ್ಬೇಕಂತ ಹೇಳಿದ್ದೀನಿ. ಮತ್ತೆ ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ದಂದ್ರೆ ನಿಮ್ದು ಇಲ್ಲ. ಅಲ್ಲ, ನಾನು ಕೆಲಸ ಮಾಡಿರ್ತೀನಿ. ಕೆಲಸ ಬಂದಿತ್ತು. ಆದ್ರೆ ನಾನ್ ಮಧ್ಯೆ ಇದಕ್ಕೋಸ್ಕರ ಸುಮ್ಮನಾಗಿರ್ತೀನಿ. ಯಾವ ಸಿಎಂ ಇಲ್ಲ, ಅಲ್ಲೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಗೊತ್ತು ಬಿಡಿಲ್ಲ ನಮ್ಗೆ. ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲ ಇರೋದಿಲ್ಲ ಅದು. ಅದಕ್ಕೆ ಆಯ್ತು. ಈಗ ಕೊನೆ ಪಕ್ಷ ಆಫೀಸಲ್ಲಿ ಎಷ್ಟಿದೆ ಈಗ ಆಫೀಸರ್ ಯಾರಿಗೆ ನಮ್ಮ ಆಫೀಸರಲ್ಲಿ ಏನ್ ನೋಡ್ಕೊಂಡಿದ್ರೆ ಎಲ್ಲಾದ್ರೂ ಇದಾಗುತ್ತೆ. ನಾನು ಹೋಗ್ತಿದ್ದಿಲ್ಲ ಎಲ್ಲ ಆಯ್ತು. ಅವ್ರು ಬಡ್ಡಿ ಪಕ್ಷ ನಾನು ಹೇಳಿದ್ದೀನಿ. ಈಗ ಹಳದ್ರದ್ದು 20,000 ರೂಪಾಯಿ, ಹೊಸದ್ರದ್ದು ಜೀವನ ಇದ್ರೆ ಮಾಮೂಲಿ ಮುಗಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿ. ನಿಮ್ಮದಕ್ಕೋಸ್ಕರ 5,000 ಬಿಟ್ಟಿಲ್ಲ.
ಇದೇನು ಅಡಾಸಿಟಿ ಅಂಡ್ ಬ್ರೈಬರಿ, ಡಿಮ್ಯಾಂಡ್ ಫಾರ್ ಮನಿ ಎರಡೂ ಇದೆಯಾ?
ಹೌದು,
ಎರಡೂ ಇದೆ.
ಇಲ್ಲ, ಅಲಿಗೇಷನ್ ಇರೋದು ಸಸ್ಪೆನ್ಷನ್ ಅಂಡ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಹೇಳಿರೋದು ಬರೀ ಅನ್ಬಿಕಮಿಂಗ್ ಆಫ್ ಅಂತ ಅಷ್ಟೇ ಇರೋದು.
ಅನ್ಬಿಕಮಿಂಗ್ ಅಂದ್ರೆ ಡಿಮ್ಯಾಂಡ್
ಓನ್ಲಿ ಫಾರ್ ದ ರೀಸನ್ ದಟ್ ಹಿ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್ ಸಮಥಿಂಗ್ ಅಬೌಟ್ ದ ಚೀಫ್ ಮಿನಿಸ್ಟರ್. ದಟ್ ಇಸ್ ದ ಅಲಿಗೇಷನ್.
ಇಲ್ಲಿ ಬಂತಲ್ಲ, ಯು ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ ಮನಿ ಹಿ ಹ್ಯಾಸ್ ಡಿಮ್ಯಾಂಡೆಡ್.
But my lord, the person who is in conversation, he has not supported the case of the department. That is, they issued 3 notices.
5,000 ರೂಪಾಯಿ ಕನ್ಸೆಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ
ಅಲ್ಲ, ಆ MNK ಅಂತ ಒಂದು ಸಂಸ್ಥೆ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. They have given statement. He has not demanded ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲೇ ಇದೆ.
ಅಲ್ಲ, this is my response to the notice is that it is a fake and I have not involved in any that. That is my stand, my lord.
Dismissed. Heard audio tape very carefully, attentively.
Withdraw ಮಾಡಬಹುದು.
Dismissed.
Lord, I may permitted to withdraw.
Petitioner, after arguing the matter, seeks leave of the court to withdraw the petition. First up,
Expeditious disposal.
Learned AGA graciously agrees for grant of leave. First up. Next paragraph. In view of the above, writ petition is disposed of as having been withdrawn, requesting the tribunal to take up the matter bit early in accordance with law. Okay. Next.
For the petitioner, Lord, writ petition itself can be disposed of. Lord, suspension order is dated only, my lord, I'll give two dates. 31/8/2024. I am sorry, my lord, 3/9/2024.
3/9.
Lord, the 6 months period expires on 3/3/2025.
2/3/2025.
2/3/2025. Lord, in view of Rule 10(5)(b), Lord, the matter is covered by my lord's decision to the effect that, Lord, no charge memo is issued. Lord, suspension is deemed.
The subject matter of this petition, comma, learned advocate appearing for the petitioner submits, comma, is substantially similar to the one in WP number 22677 of 2024 SKSAT between Sri Loknath R versus state and another. And therefore, the relief granted to litigant in the said petition has to be extended to his client as well on the principle of parity. Parity. Full stop. Next paragraph. Although learned the AGA appearing for the, on request appearing for the official respondents opposes the petition by making submission in justification of the impugned order of the tribunal, correct? Tribunal, comma. We are not convinced that the substratum of this case is different from that in the cognate petition. First off, this we say keeping in view the provisions of Rule
10(5)(b).
10(5), small 5, 5B, small b.
The KCS
Of KCS CCA rules 1957. As has been interpreted by us in the cognate petition. First off, in the above circumstances, petition is allowed.
Lord, the
Petition
suspension
allowed
is deemed to.
And petitioner's suspension dated 3/9/2024 is has come to an end with effect from 2/3/2025. First off, official respondents to act upon this forthwith.
And my lord, direction may be issued to the official respondents to give posting, appropriate posting.
By giving appropriate posting to the petitioner.
Lord, within a period of 2 weeks, my lord, I am.
The 10(5)(b) rule requires that he goes and reports.
I have reported.
If it doesn't.
I have reported on 3/3/2025, my lord.
If, comma, if petitioner reports for duty.
Please.
Within a period of 15 days, my lord.
First off, time for compliance is 2 weeks.
Please.
Next.
Similar to the other matters, my lord, my lords have granted sub-registrar suspension. My lords have granted interim order, my lord, in other cases.
Interim order idea?
Yes.
Sorry, issue emergent notice. Interim order as in WP number so and so. Call along with. Yes. Yes, Sagar.
Lord seeks 1 week accommodation.
Call application at the request of. Yes, Nagaraja.
Case of landlord, acquittal in the criminal case.
My lord, 24 ಅಲ್ಲಿ statement of objections ready, my lord. I am filing it today itself.
ಮಾಡಿರಾ? ಮತ್ತೆ ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
My lord's case, Rudrappa's case covered.
ನೋಡೋಣ. ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ನೋಡ್ಕೊಳ್ಳಿ. We'll call this on 21st.
Please.
Short matter perhaps.
Please.
PV Rudrappa ಇತ್ತು ಅಂದ್ರೆ ಮುಗಿದು ಹೋಗುತ್ತೆ.
Please.
He is banking upon PV Rudrappa.
My lord, in 21st.
21st. Next. Yes. Yes, Mr. Joyce.
My lord, I appear for the petition. Matter was for some time on the last occasion. It's a matter relating to inquiry by Lokayukta. My lord, complaint was given on 2004. The Lordship may kindly see page number 6.
Last petition, Lordship, Venkatesh Arbati is
11
appearing.
page
Lokaयुक्त has
63,
taken time to produce some documents.
where the date of affidavit is present.
Venkatesh had
Lokaयुक्त
said that
last
he
time
would
took
produce
time,
certain
madam.
documents. Venkatesh has said that he would produce certain documents.
Yes, please. Last time he has taken time.
Where is he?
Latest statements of facts for other belated enquiries are not.
Call of vacation. Next. To enable the panel counsel for appearing for Lokayukta. Okay. Yes,
Okay, for the petition.
yes.
First case of penalty of reduction of rank to reduction of pay scale to the minimum for 3 years. But entire case is dependent on one photograph, which is not marked in the evidence, but showed upon. But the person who has taken that photograph is not considered.
ನೀವು ಅದಕ್ಕೆ ಏನು ಉತ್ತರ ಕೊಟ್ಟಿರಿ ತೋರಿಸಿದಾಗ
ಅದ್ ನಾನ್ ಅಲ್ವೇ ಅಲ್ಲ ಅಂತೀನಿ ಅದನ್ನ ನಾನು ಅಂತ I have the photograph.
ತೋರಿಸಿ.
Police constable he is involved in the mining, sand mining, Lordship.
That is
Camp,
the
Lordship.
allegation, no evidence.
ನೀವು
ಆ photograph
ತೋರಿಸಿದಾಗ ಏನ್ ನಾನು ಅಲ್ಲ ಅಂತ ಹೇಳಿರ
ಆ ಫೋಟೋಗ್ರಾಫ್ ಅಲ್ಲೂ ನಾನು ಕಾಣುದಿಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟು ಇವರು ಮಂಜುನಾಥ ಅಂತ ಬರ್ದ್ಬಿಟ್ಟು ಯಾವ ಇದು ತೋರಿಸ್ತಾರೆ ಎಲ್ಲ. both are same photographs. One enlarge.
ಇದ್ರಾಗ ಯಾರು ಮಂಜುನಾಥ್ ಯಾರು?
ಫಸ್ಟ್ ನಿಂತವ್ರು ನಾನು ಅಂತ ಅವ್ರು ಮಾರ್ಕ್ ಮಾಡಿ ತೋರಿಸ್ತಾರೆ.
ನೀವೇನಂತ ಹೇಳಿದ್ರಿ? ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ
ನಾ ಇಲ್ಲ ಅಂತ
ಎಲ್ಲ ಹಂಗೆ ಹೇಳ್ತಾನೆ, ಇಲ್ಲ ಅಂತಾನೆ.
Apart from this, there is no other evidence. Apart from this, there is no other evidence.
PW 516, Your Lordship, stated in favor of disciplinary authority, Lordship, on the basis of the statement of the PW 116, Your Lordship. The disciplinary authority examined PW 126, Your Lordship.
Lordship may find PW 1 at 47.
Page
47.
89.
After vacation ತಗೊಂಡು ಏನಂತ urgency ಇಲ್ಲ.
But within first week ಅಂತ ಹೇಳಿದ್ರೆ, ಯಾಕಂದ್ರೆ ಅವ್ರ ಪ್ರಮೋಷನ್ ಎಲ್ಲ ರಿಡಕ್ಷನ್ ಆಗಿರೋದ್ರಿಂದ
ಅಂತರ್ಗೆಲ್ಲ ಪ್ರಮೋಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಎಸ್,
I was not even there.
ನೋಡ, that's your stand. Next.
This case, Your Lordship, this is regarding that.
But there are vacancies. Huh? ಏನಿದೆ? ಮತ್ತೆ ಅದು ಹಿಯರ್ ಮಾಡಿ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ನಾವು ಅವರಿಗೆ ಕೊಟ್ಟೇವೆ, ಅದೇನಾರ ಆತಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು? ತರ್ಸಿ ಅವ್ರಿಗೆ ಕೊಡಿ ಫೈಲ್, ಇನ್ನೊಂದು ಪಾಸ್ ಓವರ್ ಫೈಲ್ ಕೊಡಿ. In that matter. ಅದು ಕೊಡಿ, ಮತ್ತೆ ಈ ಕಾಪಿ ಕೊಟ್ರಿ ಬರ್ತದಿಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗ್ತದೆ. ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರ್ಕೋಬೇಕು ಅವ್ರ ಕೇಸ್ನಲ್ಲಿ, ಆ ಹಿಂದಿನ ಕೇಸ್ನಲ್ಲಿ. Subsequently, the coordinate bench having remanded the matter, the KAT, the tribunal allowed Giriraja's application number so and so, directing the government to make his appointment. First up, we are told that certain observations, stochastic observations were made by the tribunal in its order, and that the said order is put in challenge in WP number just in the connected matter. Okay.
Appear for the petitioner, my lords. Lords, I am seeking remand in this matter on two grounds, my lords. Lords, one that, my lords, what KAT does is, my lords will find, my lords, at page 40, and second show cause notice alli nan kasta agtide and I have pleaded certain personal inconvenience, and adralli adanne hidkondo acceptance agide anta merit mele hogde id madibitidare. They have not considered my first oral statement and also my first reply statement. Only second show cause notice alli ನನಗೆ ಕಷ್ಟ ಆಗ್ತಿದೆ, ದಯವಿಟ್ಟು ನಾನು ವಾಪಸ್ ತಗೊಳ್ಳಿ ಅನ್ನೋದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. And second ground, my lords, I am seeking remand is
after vacation. ಈಗಾಗಲೇ ಇಷ್ಟೆಲ್ಲ
covered by PV Rudra Bhakta. ಒಂದು ರಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರೆ ನಾನು
ಅಷ್ಟು ಸಿಂಪಲ್ ಆಗಿ ಮಾಡೋಣ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಈಗ ಹಾಕಿಲ್ಲಲ್ಲ ನೀವು? ಅಲ್ಲಿಯೂ ಹಾಕಿಲ್ವಾ KAT ಅಲ್ಲಿ? ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ ಏನ್ ಮುಗಿತು, ಮತ್ತೇನ್ ಹಾಕೋದು? ಎಸ್. ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ, ವರ್ಕ್ ಮಾಡ್ತಾ ಇದೆ ನೋಡಿ ಮೈಕ್.
Respect of appointment, my lord. Counting of seniority, my lord. Seniority.
Lords, page 14. One sati tav nod. Lords, very short point. Lords, very short point. If I may say.
In the third week of June 2025. Yes.
Lords, one submission, mercy. If I may.
Next. ನಾವು ಬರಿಬೇಕಲ್ಲ ಆರ್ಡರ್ಸ್, ಈಗ ಚಿಕ್ಕ ಆರ್ಡರ್ಸ್ ಗ್ರೌಂಡ್ ಮಾಡಿರ್ತೀವಿ.
ಅಷ್ಟು ಗ್ರೌಂಡ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ಚಾಲೆಂಜ್ ಆಗಿದೆ. 2009 ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾನು ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ದೀನಿ. 2018 ಜಾಯ್ನ್ ಆಗಿದೆ ಅಂತ 2018 ಇಂದ ಕೊಡ್ತಾರೆ ಅಷ್ಟೇ.
ನೋಡ್. Yes.
So ready. Matter relates to, there is an entry order operating in our favor. Matter relates to lords, date of birth. Lords, she was actually born in 61, my lords, but it was entered as 67. And lords, now superannuation has happened, she is out of service. Thereafter she approached the Karnataka State Administrative Tribunal. Lords, these are all daily wages, my lords. They have passed SSLC. In the marks card, my lords, those days, my lords, the date of birth was not there. However, my lords, we got a complaint that many persons who have attained 60 years are still continuing to work. So a general inquiry was conducted. It was found, my lords, that his certificate was genuine. But in the school records, his date of birth, my lords, was 61.
Is available.
It's there. I have produced it, my lords. So
which is that judgment of the apex court
Lords,
from Madhya Pradesh, where school records show the date of birth, they should be acted upon.
Lords, we have an act itself in our state. Act SSLC is the if provided.
ನಿಮ್ಮ ಅಪೋನೆಂಟ್ ಯಾರು?
ರಂಗನಾಥ್ ಜೋಯ್ಸ್ ಅವರೇ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ.
Call after vacation to enable Mr. Joyce to come and argue. Yes.
Please, grateful.
In urgency.
But the urgency is the consideration of the final gradation list of the tier.
Application. Next. Ali, ಕಳ್ಸೋದು ಅಷ್ಟೇ. ಯಾರು?
I'm seeking a pass over, Lord.
Venkatesh Arbatti, learned panel counsel is requested to accept notice for the respondent. First of Mr. Haladi is permitted to retry from the case. 3 and 4, huh? Okay. Next.
Lord, can you be passed over?
Next.
Third respondent.
Court move, ಯಾರು ಮೂವ್ ಮಾಡ್ಯಾರ? ಅವರೇ ಮೂವ್ ಮಾಡ್ಯಾರ? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ? ಏನೇನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಏನು? ಯಾವ ಮ್ಯಾಟ್ರಿ? ಏನ್ ಮ್ಯಾಟ್ರಿ?
Covered by the decision of the Supreme Court, having participated in the selection process, you cannot challenge it. There is also a dilemma. 1000 days. Dhananjay Malik case, 2008.
Recovery, ಏನದು? Participation.
Acquiescence.
You cannot turn around and challenge it.
Your acquiescence to the rule.
Next round is with respect to the preference, my lord. They are seeking to.
Next. Call of application to enable counsel for the petitioner to come and argue. Yes.
My lord, I appear for
Petitioner
the,
moved by the other side, my lord. This
I am for the third respondent in this matter, my lord.
matter of transfer, there's an interim order, it may be extended, my lord. This.
Interim order is operating against me, my lord. In this, my lord, the order of transfer is aside and interim order is operating against me till next date.
That has been extended from time to
It's a
time.
case of premature transfer. Within a span of 5 months, my lord, I have been transferred. I am working.
Lord,
as
it's only a
group
movement. My contention before the honorable tribunal was, it is only within section. It's not transfer guidelines. It's not called transfer.
Within
Movement,
section.
movement from one section to another within the same building.
So that amounts to transfer. ಅಂತ
My lords,
ಮಾಡಿದ್ದು ಯಾವ judgment?
the honorable
ಚಂದ್ರ.
tribunal.
ಚಂದ್ರನ ಯಾವ್ದದು? Even in one office, there can be transfer ಅಂತ hold ಮಾಡಿದ್ರಲ್ಲ.
My lords,
Other table also is a transfer.
one more aspect is, my lords, even before the honorable tribunal allowed the application, he was given a subsequent posting which has accepted he's working there. He has not laid a challenge to that application at all, that order of transfer at all.
My lord,
Therefore,
there also, that order also I have questioned, my lord, subsequently. Both the orders under challenge, my lord, in this, before the KAT. KAT has allowed my application and against which, my lord, the petition.
ಯಾವ್ದು ಚಾಲೆಂಜ್ ಆಗಿದೆ?
no, my lords, that is not challenged, my lords.
Both
The
are
order dated 12th of February 2024.
No, that order was given because of transfer order.
Please, my lord.
If transfer order is unsustainable, then that also goes. Ex nihilo nihil fit.
My lords, I was posted to his place, my lords. There was no interim order of stay, my lords. He was posted as section officer within the same.
Challenge is to the transfer order dated so and so before the tribunal. First, tribunal in application number so and so filed with the private contesting respondent has allowed it on the ground that it was a premature transfer made in contravention of extant transfer guidelines dated.
Dated 13/6.
My lords, may I submit, my lords? 7/6 guidelines will not apply. It is 7/5 to.
You are saying that movement ಅಂತ ಅನ್ಕೊಂಡು.
Yes, my lord, it's called a movement. Transfer guidelines which prescribe recording of reasons premature did not apply in case of movement within the section officer.
Show that judgment.
Yes, my lord, I'll show.
ಯಾವ judgment ಅದು?
It's in the transfer guidelines itself, my lords.
ಅದು ಲೇಟೆಸ್ಟ್ ಗೈಡ್ಲೈನ್ ನಾಗ.
No, my lords, in the transfer guidelines of 7/6/2013, there's a schedule which says that within movement, for movement of officers within the secretariat, he is the secretariat employee from one section to another section, recording of reasons, all that strict mandate which is there in 7/6/2013 will not apply.
Not apply ಅಂತ.
Yes, my lords.
So it
I will
requires
produce all those documents. my lord.
ಒಂದು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಆ ರೀತಿ ಹೋಲ್ಡ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್
Yes, sir.
ಅವು ಅಪ್ಲೈ ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ವಿ ಅದು ಧಾರವಾಡದಲ್ಲಿ. Requires consideration.
Yes, my lords.
No, we have already given one judgment on that. So, recall that order. All right. Call immediately after occasion, interim
Next
order
week,
to
next-
continue. Yes,
Next week, my lord.
next week not possible because we are in so many benches. Okay.
Please.
Let's interim order as existing may be.
Yes, that will
Great.
continue. Okay. Mulidhar.
Kindly pass over, my lord.
Oh, pass over. What is the urgency? 2024 matter. We have many orders to dictate now. Will not sit idle. By the time we go home, it will be 8 PM. Sometimes it exceeds that also. Though we spend, we raise little early, lot of work we have to do. East matters dispose of order baribeku.
Please, kindly have
Till
it
date is
day
fixed
after
at the
tomorrow,
instance
madam.
of learned AGA finally. ಏನ್ ಬ್ರದರ್ ಇದು ನಿಮ್ಮ ಏನೋ ಫೈನಲಿ ಅಂತ ಏನೋ ಹಾಕೊಟ್ಟೇವಲ್ಲ ನಾವು 35. ಏನಿದು ಏನಮ್ಮ ಏನ್ ಪಿಟಿಷನ್ ಏನು
My lord, kindly have it day after tomorrow, my lord.
Day after tomorrow?
Please.
Well, immediately after vacation. Vijay, ಏನಿದು?
It relates to promotion and seniority of the private respondents is under challenge, my lord.
Private respondent is under challenge.
Challenge.
Tribunal granted relief to your
The
respondent.
private respondents.
Non draft vacation.
This is a case where, my lord, we are appointed directly in the RDPR department. My lord, they entered into services in the PWD department. My lord, in the year
ಇದು
2007.
ರೇಣುಕಾ ಪ್ರಸಾದ್ ಆಗತ್ತೇನೋ?
No, my lord, this is relating to bifurcation. My lord, what has happened was we were all appointed in 2003, my lord, against the combined vacancies of PWD, RDPR and Water Resource Department. Subsequently, in 2008, my lord, RDPR was constituted, separate rules were framed.
It was the earlier part of the same department.
Yes, my lord. Subsequently, it was 2008, my lord, separate rules were framed for RDPR. My lord, in 2019, my lord, they took a decision to, my lord, bifurcate the RDPR, Water Resource and PWD separately. My lord, a conscious decision was taken not to effect any promotions during the pendency of the bifurcation process. But ignoring that, my lord, though the heads of the department of RDPR were party to the proceedings in the meeting, but they proceeded to initially place these private respondents who were appointed in 2016.
After your
Yes, 2003 is my appointment.
Not correct.
2016, my lord, they were appointed against the, in terms of 2008 rules, RDPR rules. Now, my lord, before they could be, the bifurcation could take place, my lord, they are being placed under Rule 30 and they are being promoted. Though there is a specific direction, my lord, by the committee itself saying that they should not affect any promotions in any of the department. And if they want to, my lord, it has to be through only PWD.
Was he also a party to the proceedings?
Yes.
He was also party.
Yes.
Not true, my lord. My lord, what they happened,
And requires consideration.
2007, my lord, rules were framed.
ಇಲ್ಲ entry ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ?
Lord, there's no interim. Now they are trying to, my lord, promote the private respondent further as executive engineers.
My lord, earlier it has
On the
called,
basis
my
of
lord,
erroneous seniority in the senior assistant executive engineer.
Don't promote anybody.
My lord,
Till the
kindly
next
see,
date
my
of
lord,
hearing.
I make submission. 2007, when the RDPR department, my lord, separately framed the CNR
When
rules.
you were appointed, when he was appointed.
My lord,
They were appointed in
Obviously, subsequent to-
2016, my lord. I was appointed in
I
2003.
was, my lord, appointed, no doubt, my lord, after their appointment, 2007, when the RDPR department separately rules were framed, an option was given in the rules itself. my lord.
But they said, don't appoint, make any promotion. Don't make any appointment
they are-
during the
they are-
separation process.
Yes.
Even then he does that.
Yes.
What
No, my
else
lord.
is required?
RDPR department into the PW, from the PWD department, 2007 option was called for, they have not exercised the option. 2013, government order was issued for seeking the option, they kept quiet, they continued in the PWD hoping that they will get the promotion. 2014 also, my lord, they have not exercised the option. My lord, once the options, my lord, they have not exercised, RDPR department decided to make a special recruitment in which we applied. We directly recruited, nobody has questioned it. And
that happened?
Well, they exercised the
2013.
option.
2016, my lord.
They exercised the option only after our promotion to the cadre of assistant executive engineer. They.
My lord,
they
a
are
decision was
spending
taken,
us
a decision was
sitting on
taken
the
to
fence, my lord.
bifurcate only in 2019.
Well,
My lord, I have exercised
they are
option
sitting
in
on the fence, my lord.
2019.
They are sitting on the fence. Whoever exercised the options, well, they were given the article department, they have been promoted.
And subsequently, the rules have been amended.
Good morning, you later
No.
happen.
Subsequently, rules have been amended in 21, my lord,
21
including our absorption also under rule 2, sub-rule 2 of the 2008 rules. That has been amended.
Lord, the interim protection is given to a limited extent of saying that further promotions will be subject to the outcome of this case. Given on 19.
Any promotion is, my lord, any promotion is there, my lord, that is.
Then it requires consideration, some complexity.
19/7 interim order is given.
Interim order is there.
Lord, interim
All
order
this
is
matter.
subject to, my lord, let them not
No, my lord,
precipitate the
my
matter.
lord, our
It is already
promotion.
interim order. What kind of, ಅದನ್ನ ವೇರಿ ಮಾಡ್ಲಿಕ್ಕೆ ನಮ್ಗೆ ಗ್ರೌಂಡ್ ಬೇಕಲ್ಲ ಮಾಡಲ್. Sorry, call immediate application. Because you did not exercise option at all.
No.
Uh.
My lord, that is not the issue. Issue is
No,
that
no,
a decision
no.
was taken to bifurcate, my lord, in
No,
2019.
application.
Pursuant to the bifurcation decision, my lord, I have exercised my option on a notification issued.
Next.
That cannot be a ground, my lord, for the reason that subsequently to rule 2, sub-rule 2 of the 2008 rules also came to be amended.
All right. 37.1 ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ ಬರಿ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು R4 to R8 R1 to R3 AG. Okay.
Application.
Application. The notice ಆಗಿ ಬರಲಿ. Yes. Yes, Rangnath Joyce.
Well, kindly pass over, my lord. Kindly. Senior is end up in a.
No,
Kindly
call this matter on 21st. ಏನಿದು matter? Promotion. Call application. 39. Ritesh. Yes. You appear for Amrutesh.
Yes. I have got a wakalat.
You are separate.
39.1.
ಏನು matter ಏನಿದು?
The matter is, your lordship.
Relating to what? Seniority, promotion, DE, what is that?
Regarding the inquiry, your lordship.
DE.
Yes. 4 increments, cumulative increments, and.
What is the allegation?
The allegation is that I have allowed the trees to be cut and removed and transported. There is no, it is not proved. The investigating officer himself says, I am not responsible. Investigating officer himself, my evidence is there. He says she is not responsible. The Loka Ayuktha, before initiating all the charges, they called for 2 reports from the assistant forest officer. 2 assistant forest officer gives a report that I have no role to play.
Then why they did not agree with that?
Your lordship, the very peculiar inquiry officer, without looking into that, he says the charge is proved and recommends for this, your lordship.
No, application ಬರಲಿ. Consideration ಆಗ್ತದೆ. ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಅಷ್ಟೇ ಇತ್ತು ಅಂತ ಇಮಿಡಿಯೇಟ್ ಫಸ್ಟ್ ವೀಕ್ನೇ ಹಾಕೊಳ್ತೀವಿ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ. All in first week of June. Since a short point is involved. Okay, next. ಅದ್ಯಾವುದೋ ಇನ್ನೊಂದು ಇತ್ತಲ್ಲ ಅದು ಆದಿತ್ಯ ಯಾವುದು 40 Vipin Hegde last matter.
I apply for petitioners. Senior has some fever, my lordship, today.
Okay, not well.
Not well.
Why, what happened to Vipin?
No, not well, my lordship.
Okay. After vacation hakoona?
Please, my lordship.
Call after vacation at the request of.
Great.
Tell him we have wished a speedy recovery. Aditya. Buddy.
My lords, I'm here, my lords, if your lordships
Yes,
permit me
Mr.
to my lords
Goya.
appear virtually.
We will not hear you. You are
Yes,
avoiding
my
our court. We will not hear you.
My lords, I wanted to make that request, my lords. I will physically come before your lordships if your lordships would give me, my lords, if I can make that prayer on the 17th, my lords. I'm in Karnataka, my lords.
17th, without miss, whether you have work or not, you have to come here.
Yes, my lords. I promise.
All work and other attractions also at Delhi.
Yes.
17th,
17th, my lords. Yes, please, my lords, 17th.
17th. ಅಲ್ಲಿ heard. Full stop. Heard him, call on 17th as requested by the senior advocate Mr. Ovaya appearing for the petitioner.
My lords, I'll just take only one second, my lord. My lord. It's a short issue. I only, my lords, win or lose at my lord's threshold on the issue of whether principle of natural justice not given to me at the first level, can it be cured at the second level? That's the only issue, my lords, and I'll make my submissions on it.
Okay. Other ಮೇಲೆ ಏನು if opportunity is given in the upper stage, that will suffice ಅಂತ ಅನ್ನೋ rulings ಇದೆ, ಸ್ವಲ್ಪ contrary rulings ಇದಾವೆ, ಎರಡು ಸೈಡ್ ಇದಾವೆ.
Yes, my lords. Fortunately, in 2025, my lords, a 3-judge bench of the Supreme Court, my lords, indicates specifically confirming the first set of rulings, saying that deficiency of PNJ at the first level cannot be cured at the second level.
ಇಷ್ಟೇ ಪಾಯಿಂಟ್.
That's the point, my lords. I'll come on the 17th, my lords, with those decisions.
17th, but otherwise he will not come. He will forget Karnataka, perhaps.
No, my lords, I will.
Being a Kurgi, you cannot afford to forget us. You are the soldiers who have fought for the country, military generals.
I will be there, my lords, come what may.
Please come. Please come. Yes. Yes, next. 27.1.
Lordship, kindly see the page 283, criminal order, Lordship. May I read?
ಎರಡೂವರೆಗೆ ಬನ್ನಿ, ಓದ್ಕೊಂಡು ಇದೆ ಕೊಡ್ತೇವೆ, ಸಿಟ್ಟಿಂಗ್ ಇದೆ. 2:30 ಬನ್ನಿ. ಅಲ್ಲಿ ವೇಕೆನ್ಸಿ ಇದಾವನು?
I'm appointed also, my lord. Continuing.
Appoint ಮಾಡಿದ್ದಾರೆ.
ಒಂದು ರಿಮಾರ್ಕ್
My lords, permit me one memo, my lords. Lords, pending matter, order of compulsory retirement interfered by the tribunal, stay has been granted. But ನನಗೆ pension ಕೊಡ್ತಿಲ್ಲ, provisional pension ಕೊಡ್ತಿಲ್ಲ ಕಷ್ಟ. IA for direction.
ಹಾಕೊಳ್ಳಿ ಅದರ ಒಂದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ವರ್ಷ ಆರ್ಡರ್ಸ್ ಕಳಿಸ್ಬೇಕು. Start dictating. Nine disposal.
Deeply. Next week, ಸರ್ ಯಾವಾಗ? ಸೋಮವಾರ ಗುರುವಾರ ಡೇಟ್ ಇಲ್ವಾ? Thank you, sir. Sir, IA for direction. IA for direction.
Court officer. Court officer.
ನೋಡಿದ್ದು ಸರ್. ಸರ್ ಹೇಳಿ.
Serial number 36 ಏನಾಯ್ತು ಸರ್?
After summer vacation, sir.
Okay, sir. Thank you, sir.
ಏನ್ ಹೇಳಿದ್ದೀರಾ? Super fast ಇದೆ ಯಾಕೋ ಸಾಹೇಬ್ ಬಂದಿದ್ದನ್ನ ನಾನು ಸ್ವಲ್ಪ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀನಿ ನಾನು ಮಾಡ್ತೀನಿ ನಮ್ಗೂ ಡೆಲಿವರಿ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ऐसा चंदे मांगे अभी ये तू ना कोई
सर ಇದು ಕನೆಕ್ಟ್
ಆಡಿ ಶೀಟ್ ಬಂತು ಕೊಡಿ ಸಾಕು
37 ಪಾಯಿಂಟ್ ಯಾಕೆ ಹಾಕ್ತೀರಾ ನೀವು? ಕೆಲಸ ಇಲ್ಲ ನಿಮಗೆ ಎಲ್ಲ ಪಾಯಿಂಟ್ ಈಗ ನನ್ನ ನಂಬರ್ ಮಾಡಿರಲ್ಲ ಅಲ್ಲೆಲ್ಲಿ ಇದೆ ವೇಟ್ ಮಾಡಿ ಮನೆಯಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಸರ್ ಈಗ ಮಕ್ಕಳು ನೋಡ್ಕೊಬೇಕು ಸರ್ ಮಕ್ಕಳು ಒಬ್ಬನೇ ಇರೋದು ನಾಳೆ ಗೊತ್ತು
ಹಾಕೊಂಡ್ರೆ ಬೇಡ ನಾನು ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಚೇಂಜ್ ಮಾಡೋಣ ಹೇಳಿ ಓದ್ನ ನಾನು ದುಡ್ಡು ಹಾಕ್ತೇನೆ ಆಗಿದೆ ಎನ್ಸರ್ ಮಾಡಲ್ಲ ವೆಕೇಶನ್ 1 ತಿಂಗಳು ಮೊದಲೇ ವೆಕೇಶನ್ ಇದು ಸ್ಕೂಲ್ ಯಾರು ಎಲ್ಲ ಕಡೆ ಅಪ್ಲಿಕೇಶನ್ ನಾವು ಬರೀ 5 ಎಲ್ಲ ಕಡೆ 5 ಗಂಟೆಗೆ ಹೋಗ್ತೀವಿ ಓದೋದು ಇದು ಮಾಡಿ ಕೇಳಬೇಕು ಅವ್ನು ಕಳಿಸ್ಬಿಡ ನೀನೇ ಇಲ್ಲ 11:30 ಎಲ್ಲ ನಾವು ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲಿದ್ದಾರೆ ಕೇಳ್ಕೊ.
ಫೋಟೋಸ್ ಇಲ್ಲಪ್ಪ ಹೌದಾ ತಿರ್ಗಾ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್ 2:30 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಮುರಳೀಧರ್ after vacation.
Sorry, ನಾನು in fact I was on the experiment.
ಗೊತ್ತಾಯ್ತು, ಅವ್ರಿಗೂ ಹೇಳಿದೆ ಅದೇನೋ ಅವ್ರು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದಂತ ಅವ್ರಿಗೂ ಹೇಳಿದೆ, ನಿಮ್ ಜೂನಿಯರ್ ಸ್ವಲ್ಪ ಹೇಳ್ಕೊಡ್ಬೇಕು ಏನಾದ್ರು ಅದ್ರ ಬಗ್ಗೆ. ಪಾಪ ಅವ್ರು ಪಾಸ್ ಅವ್ರು ಆದ್ರೂ ಹೇಳ್ಬೇಕಾಯ್ತು. ಹೇಳಿದ್ರು ಆಮೇಲೆ ತಿರ್ಗಾ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಂತ ಏನಕ್ಕಂದ್ರು ಹಾಕೊಳ್ಳಿ. ಇಲ್ಲ
ಏನ್ ಮಾಡ್ಲಿ, ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ 2:30 ಬಿಟ್ಟು ಮಾಡ
ಅದು ಅವ್ರಿಗೆ ಹೇಳಿದೀರಾ ಅವ್ರಿಗೆ ವಿಕಾಸ್ ರೋಜಿಪುರಕ್ಕೆ ಹೇಳಿ 2:30 ಬಂದ್ಬಿಡಿ, ಹೇಳ್ತೀನಿ ಅವ್ರಿಗೆ ಹೇಳಿ ಪಾಸ್ವರ್ಡ್ ಅಂತಾನೆ ಹೇಳ್ಬಿಟ್ಟು ಅದೇನೋ ಕೇಳಿದ್ರಲ್ಲ ಕೇಳಿ ಏನಂತ ಎಸ್ ಅಂದ್ರೆ ನಾನು ಕರಿತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕ್ತೀನಿ ಅವ್ರಿಗೆ. ಹೋಗಿ ಮಾತಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಈಗ ಹೋಗಿ ಮಾತಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅವ್ರಿಗೆ. ಇದೆ ಅವ್ರಿಗೆ ಏನ್ ಡೇಟ್ ಅಂತ ಕೇಳಿದಾರೆ, ದ ಡೇಟ್ ಇಸ್ ಫಿಕ್ಸ್ಡ್ ಅಟ್ ದ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಅಂತ ಏನಕ್ಕೆ ಅವತ್ತು ಏನಕ್ಕೆ ಏನ್ ಪಾಯಿಂಟ್ ಇದೆ? ಫಸ್ಟ್ ಅವರು ರೆಡಿ ಇದ್ದಾರ ಕೇಳ್ಕೊಂಡ್ ಬನ್ನಿ, ರೆಡಿ ಇದ್ರೆ ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೋಸ್ಕರ ರೆಡಿ ಕೇಳ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಡೇಟ್ ಏನಿಲ್ಲ ಸರ್, ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್. ಜೂನ್ ಅಲ್ಲ, ಜೂನ್ ಯಾವ ಟು ಮೂವ್ ಅಲ್ಲ, ಸೇಮ್ ಕೊಟ್ರಿ ನಮ್ದೇ ಬೆಂಚ್ ಬರುತ್ತಂತ ಗೊತ್ತಿರಲ್ಲ. ವಿ ಕಾಂಟ್ ಫಿಕ್ಸ್ ದ ಡೇಟ್ ಫಾರ್ ದ ಸಮ್ ಅದರ್ ಬೆಂಚ್. This means after vacation only. Only 2 days, only 10 days are working, that's all. His lordship won't take pending matters, big group matters, that's why. Because you must be ready with the facts and all. ನಾನು ಬರ್ತೀನಿ ಬಿಡಿ, ಒಂದು ನಿಮಿಷ ನಾನು ಬರೀತೀನಿ, ಆರಾಮ ಕೂತ್ಕೊಳ್ಳಿ. ನಾನು ಗೊತ್ತಾಗಲ್ಲ, ನಾನು ಬರ್ಕೊಂತೀನಿ ಒಂದು ನಿಮಿಷ.
ಕೇರ್ ಲೇಡಿ ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತಾರೆ. ನಾವೇನ್ ಹೇಳ್ಬೇಕು ಸರ್? ನಾವು ಉದಾಸ್ ಅವರು ರಿಟೈರ್ಡ್ ಆಗ್ತಾರಲ್ಲ, ಇಲ್ಲ ಮೇಡಮ್ ಅವ್ರು ಬರಲ್ಲ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅವ್ರಾಗ ಅವ್ರು ಕೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ನಿಮ್ಮ ಕೆಲ್ಸಕ್ಕೆ ಮೆಚ್ಚಿದ್ದಾರೆ ಅಂತ. 1-2 ತಿಂಗಳು ಬಂದಿದ್ರು ಸರ್.
21/3/25 ಬಂದಿತ್ತು. 21/3/25ಗೆ 21/3/25ಗೆ ಅದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗಿದೆ ಏನಂತ ನೋಡೋಣ ಅಂತ ಅಷ್ಟೇ. 21/300 ಬರ್ಕೊಂಡಿದ್ದೀನಿ, 21/300 last week of April 2025. ಬಂದಿಲ್ವಾ ಅದು? 21st ಯಾವತ್ತು ಈಗ? ನಾಳೆ. ಈಗ ನಾಳೆ ರೀಚ್ ಆಗಲ್ಲ, ನಾಳೆ ಡೇಟ್ ಎಷ್ಟು? ರೀಚ್ ಆಗಲ್ಲ, ಇಲ್ಲೇ ರೀಚ್ ಹಾಕ್ಸು ಅಂದ್ರೆ ಹಾಕಿಸ್ತೇನೆ. ಅದು ರೀಚ್ ಅಂತ ಆಗಲ್ಲ, 2:30 ಸಪ್ರೇಟ್ ಇದೆ. ಯಾಕೆ ಸುಮ್ಮನೆ ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ವೇಸ್ಟ್ ಆಗೋದು ಬೇಡ. 9 ಟ್ಯಾಕ್ಸ್ ಇದೆ. ಅದು ಬಿಟ್ಟರೆ ಏನಿದ್ರು ಹಿಂಗೆ ರೀಚ್ ಆಗ್ಬೇಕಂದ್ರೆ 15th ಬೆಂಚ್ ಇದೆ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಲಾಸ್ಟ್ ಬಂತು ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಷ್ಟೇ ರೀಚ್ ಆಗಲ್ಲ. ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರು? ನಾಗರಾಜುಲು ನಾಯ್ಡು ಬರಲ್ಲ, ಅವನನ್ನ ಆಗಲ್ಲ. ಪೆಂಡಿಂಗ್ ಮೂವರ್ ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಅಂತ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿ. ಸಬ್ಮಿಷನ್ ಮಾಡಿ 2:30. ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಅನ್ನೋದು ಏನಕ್ಕೆ ಹಾಕಿಲ್ಲ ನನ್ನ ಮಕ್ಕಳು ಅವರು? ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ 21/3 ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್ ಅಂತ. ಲಾಸ್ಟ್ ವೀಕ್ ಬರ್ಬೇಕು ಅದು. ಓ ನಾನು ನೋಡಮ್ಮ ನಾನು ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಮಾರ್ಚ್ ಅಂತ ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಎಷ್ಟೇ ಮೆಮೊರಿ ಕೊಡ್ತಾರದು? ಮುಂಚೆ ಕೊಟ್ಟಿದ್ರ 2021 ಲಾಸ್ಟ್ ವೀಕ್ ಆಫ್ ಏಪ್ರಿಲ್. ನಾನು ಏಪ್ರಿಲ್ ಮಾಡ್ಕೊಬಿಟ್ಟಿದ್ದೀನಿ ನಾನು ಬಂದ್ಬಿಟ್ಟು ನಮ್ಗೆ. Seven 12/2022 ಸ್ಕ್ರೂಟಿ ನಾಳೆ ಬೇಕಾ? ವೆಡ್ನೆಸ್ಡೇ ಡೇ, ಟ್ಯಾಕ್ಸ್ ಡೇ. ಪೆಂಡಿಂಗ್ 2 weeks.
ಅಪ್ಡೇಟ್ ಮಾಡಿಲ್ಲ,
ಅಲ್ವಾ ಮಾಡಿಸ್ಬೇಕು.
ಮಾಡಿಲ್ಲ, ಇದು ಆದ್ಮೇಲೆ ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ.
ಡೀಲಿಂಗಾ ಅದು ಮಿಸ್ ಆಗ್ಬಿಡ್ತದೆ ಅಂತ ಅಲ್ಲ, ಡೀಲಿಂಗ್ ಮಾಡಿದ್ರೆ
ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಇದು ಕಾರ್ಡ್ ಎಷ್ಟು
after summer vacation, Gangadrappa to come and argue. To enable learned counsel for the petitioner to come and argue. ಬಂದಿಲ್ಲ ಅವರು. ಮಿಕ್ಕಿದದಲ್ಲೇ ಬಿಡಿ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಟೆಂಡೆನ್ಸ್ ಒಂದು ಕೊಡ್ಬೇಕು ಸರ್. ಎಷ್ಟು ನಂಬರ್ ಏಳು ನಾಲ್ಕನ್ನ ಡೇಟ್ ಕೊಡ್ತಿದ್ದೀವಿ ನೋಡಿ. ಮ್ಯೂಟೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಾ? ಇಲ್ಲ ಮಾಡ್ತೇನೆ.
ನಾನು ನೋಡಿಲ್ಲ.